Yes. Both the writ appeals 2024, late 2024, and the bank is the writ appeal.
Bank is in writ appeal. Service matter.
No. This is service matter.
Service matter.
So we have assigned the order of.
When do you want?
We want on Monday.
Monday.
Interim order.
What is that interim?
Interim order, my lord, in what they have. The Honorable Single Judge directed this appellate of to consider. But in the meantime, he has also passed the order that pay him all these dues.
It's a writ appeal, my lord. State has challenged the order passed by the Honorable Single Judge, wherein I am the respondent here, my lord.
Any interim order is granted?
My case was allowed, my lord.
Now you are seeking posting of that matter?
Posting of the matter.
Week after.
Next week,
week after. 2 weeks.
When you got the other side mentioning, they should inform because they
have you not the other side? Because they have to be, otherwise they will be taken by surprise.
And they are the.
They will take time.
They are the appellants.
It's a instrument.
Whatever you have, because you are not a dominant letter.
Inform the others.
Their case. You don't have to take up their.
Otherwise, we have to grant one time to them. They will say we are not ready.
The writ appeal prepared by the state, my lord. And the writ petition
is allowed.
The writ appeal, my lord, the proceeding with the content, my lord.
Content matter is pending now.
My lord.
So you want writ appeal to be taken up? Next week. When contempt is posted?
Contempt is posted.
Next week.
This is regarding fresh admission of a writ appeal. It was
which year matter?
2025.
25 matter. What is the urgency?
In this, the Honorable Single Judge had caused the entire selection process regarding the post of Assistant Soil Conservation Officer, and the present appellants were not impleaded as parties.
You were not impleaded?
No.
But for selection, for quashing of selection, selectees need not be impleaded is the version of Supreme Court, because selection per se does not create any right in you. Anyway, we'll have it week after next. Week after.
The state had also filed a writ appeal.
Week after next, along with writ appeal number.
The writ appeal 2024. The urgency is that to petitioner file the application for a direction to the education to dispose of the education case of 2013.
One second. Brother, say something. Just speak.
Sorry.
No, they should stop. Yes.
Not the writ of 2024. My urgency is that I have filed the writ application for a direction to the education tribunal to dispose of the execution case of 2013.
To early disposal.
But
because of Rahul Shah versus so
that was dismissed. In that, this court has no power to. You're also only simple direction.
See, direction may be very simple. Suppose if you say direction, that yet should go to Jagannath temple.
No.
Very simple. Can we give that?
Only disposal.
That does not even simplicity. Anyway, next week. Bring that judgment. Rahul Shah versus so and so, 2021 or 22. Okay? Which says all executions should be disposed of within a period of 1 year. Bring that judgment.
Milord, with permission, Milord, item number 10 today's list, Milord, item number 10, I am for the petitioner, Milord, the permitted to withdraw the reason being metro account was closed on a settlement, Milord.
On settlement?
Settlement.
Who appears as your friend on the other side?
Milord,
within 10 generally, within 10 is mentioned.
Serious hearing is there.
Yeah. Let us see. We'll grant you, perhaps hopefully, subject to what other side will say.
Page 3 item 18.
Huh?
Page 3 item 18.
18.
One chapter.
Writ appeal 507 of 23.
Yes.
Yes, sir.
May one chapter.
1 week adjournment you want. On what ground?
Because I am not prepared.
Not prepared. Do you have objection? Call this matter next week at the request of the council. Appearing
1 week is going with him.
one week or 1 day?
1 week after.
1 week. 1 week. 7 days.
Right. Same chapter.
Call after 1 week.
Yes.
As requested by learned council, appearing for respondent.
Page 8, item 47.
27.
In the past matter, I had taken time to appear for the respondent. Document could not take bullet time, pay 1
And for the respondent.
When we can be granted.
Also.
Same order.
Since March, this taken time to file the document.
For filing wakalat.
Yes.
Well, wakalat is to be manufactured on giving an order to some Delhi company.
Monetary matter, I am the applicant.
Then we tell you to take the, we tell you that you appear for respondent, since already you have power in the connected matter. In the meanwhile, you file wakalat also. Call after 1 week at the request of so and so for filing power, finally. Otherwise, we will not permit you.
363. We are connected. This is yes already.
363. All along with the act. All along with 363. Yes.
Can I try to fix a date, ma'am?
Along with 313. Along with 313. Okay. It will come.
Awesome.
Old matter, item number 1.
Yes, sir. 2006 matter, 19 years. 24 years. 19 years. Yes. Yes, who appeals? Does it survive for consideration at this length of time?
So, is it a order against entry order?
My lord, it is entry order, but in the meantime,
But the company appeal of OTM has been long since disposed of. I mean, company petition, sir.
Company petition.
But those, instruction you have to give us.
But the updated information.
It's 2006. See, the 63 is a miscellaneous petition. Page 43, order number 134. System. That will say that it is disposed. Hold on. It matches with the final order. Company Act number 25 of 2001. I'm not sure whether it is available, but check it. Check to we have the data. That is should do it.
But we check from our record, from computer. Okay.
From computer.
Okay.
Which file?
Wait, one is waiting.
Yes.
In the meantime, that has
Yesterday I realized that all are the entry model. I was thinking
The main matter
long since disposed of has merged with the
final order.
Company group for the
is 42. 25 of 2009.
So nomenclature is different. Since it is 2001, this is COMP.A Act. But is it COPET? Could be a temporary still.
Nothing.
Searching a wrong nomenclature, it's nowhere.
Nothing.
Hello. follow what very good. Whenever you are listing the whole matter, you have to mention in the first list whether the main petition is still pending at the date of disposal. That's the usual registry should do it. Arranging of the so and so, then the disposal of so and so. That's what we do. You can't just but we treated only that it is that class of the Yes, tomorrow. This is put up a note regarding put up a note not regarding regarding status of the COMP dot Act number 25 of 2001. Responsible to review whether the same petition is still pending or disposal or disposed of. Yes, Mr. Vishal, this matter is yours, madam. It's a company affiliate of Sugar Changing Connection 10. Connection 10 is the order dated. It was the passing pulpit number, but it was 2024. This will be in High Court website also. Don't have to go to Google. It's an
2000.
Same one. You are not sure. Because this predates your coming into profession. If I may pray, can I get a soft copy of the deed so that I can assist you a lot? You can take from the registry. I think there is no restriction. Again, before Monday, your lordship. You can take it in a pen drive. Fine, it's a normal notice. Wait, also giving the copies of copies. Sir, I think there is a procedure.
The direction of the court they will give.
Normally, they don't give.
The lordship directed, then they will.
As requested by the Grand Council, Mr. Vishwa, now appealing for the affiliate. He is provided with a soft copy of the petition. Much beautiful. Yeah, because Monday, your lordship, Felix is short point with the next petition is still pending. Then there is a point of the lordship. As you are not sure, we are ascertaining it. Tomorrow you will know it also. At page 114, your lordship, but I have understood and I have seen the program will dispose of it. Yes,
Then we dispose of this matter.
tomorrow.
We can dispose of this matter on the premise that the order from which this the matter from which this order has arisen itself is disposed. Okay, but to move revival, seek revival in the event matter is restored or otherwise.
I shall ask you this.
Sorry, what I said.
Sakshi Rao on behalf of Mr.
Says no. That was 7.
What is the final order? None appears. First, call next week for possible dismissal. Possibilities. Registry to show this in the solution issues. Whether the COVID is complete. I'm not sure if it's
Yes. None appears when case is called out. Full stop. Call this matter next week for possible dismissal. Full stop. Registry to print it in the cause list itself.
Whether the main scope is still pending.
Registry to submit a report as to whether the main matter from which the impugned order emanated still pends. Yes. You want to
Item 10, Milord.
You want to withdraw?
With permission, I am DC Milord. They are permitted to withdraw this company appeal 7/2015. The reason being the matter was settled, the account was closed.
Online?
I am for the petitioner, Milord. I am for the petitioner.
COA.
COA it is. Appeal, no?
Appeal.
Which matter you want to withdraw? Others matter you want to withdraw, or your matter you want to withdraw?
Milord, my matter, item 10, Milord. Item.
10 only is appeal. COA.
Yes, company appeal that was.
Learned counsel appearing for the petition appellant online seeks leave of the court to withdraw the appeal unconditionally. First stop. Right to file right to agitate includes right to withdraw the agitation in legal process. Said the Supreme Court. First stop. In view of the above, and there being no objection from the other side, leave as sought for is accorded and appeal is disposed of as having been withdrawn with no liberty to agitate on the same cause of action. Okay.
Obliged.
Can you file a memo?
Definitely, Milord, I mean, yes, definitely. Today, the course of the day, I will file the memo, sir. Definitely.
Learned counsel for the appellant undertakes to file a memo to this.
Course of
Okay.
Obliged.
Yes, addition. Item number 11.
11 time after lunch.
After lunch?
Yes.
Why are you hungry now?
Okay.
Pass over.
Item 12.
After lunch.
After lunch. All right. Same one. Pass over.
Item 13.
The melody in item 13.
Yes.
Last occasion due to non-appearance of the respondent, the order was passed on 7/3/2025 that to state to service the notice through local police. It has been issued,
Notice is served.
It is yet to
Notice not served.
My lord, notice is issued, my lord, but so far the service of notice registry has not submitted.
What the police did? What your police did? You are from the state.
I am for the state.
Where is your police officer?
That I will appraise.
Ask him to be here by 2:30.
It is from Rinkanal, my lord.
Huh?
It is from Rinkanal, my lord.
This 7/3/2025.
Yes, ma'am.
We are 18/6/2025. If police has not done, we will direct his arrest and detention.
My lord. Yes, ma'am.
You have done that.
It is.
All right, keep that police officer tomorrow before the court. Ask him to come here.
It is a tomorrow.
Tomorrow, my friend. Important bench of this court by order dated 7/20/2025 as said as under. Next note. There is no report of compliance of disorder by the jurisdictional police. Though more than 3 months have lapsed since the above one. This is not an appealing to happen. This gives doubt as to complicity of the police in unduly helping quarters that be. Next part, in view of the above, who is the in charge police officer?
That I have to. Because there is
superintendent of police.
IIC.
Huh?
My lord, concern IIC, my lord.
I see.
Inspector in.
Who have sent it? And
My lord, that name, my lord, that notice is not accompanied in the brief, my lord. That I will ascertain, my
letter or
lord.
notice, whatever,
No,
you are so tentative, our order will be then.
you keep superintendent of police personally present.
My lord, I will appraise it tomorrow. I will take it.
District.
My lord, Kanmal is a district.
District.
Yes.
The district.
No, Kandamal.
The superintendent of police
Yeah,
of so and so district is directed to be personally present before the court tomorrow in the morning. One person absence will be viewed very seriously.
Lord, may I pray? I will take instruction by tomorrow. If
Nothing. We are here to defend the court. People should believe us. If police take more than 3 months to send the notice, it is a breakdown of machinery of the state. Yes. Ask your SP to be here. Otherwise, we would have directed Director General of Police.
no, my lord,
This
my lord,
they are doing
good, I will ensure.
it in present. I don't want to tell him also why we are calling him here. Yeah. I don't want to.
For the opposite party, play for the adjournment.
What do you?
Well, I don't have.
What's this matter?
Here, my lord, last thing. So far the respondent is concerned, this was also issued notice through police and it has been made sufficient. And my learned friend is for the.
My lords,
Yes.
well, appeared prior to that, the order dated 7/2/2025, my lords, we entered appearance, my lords. I need some time to seek instructions, my lords, so for that reason I play for the notes.
Last time also you were absent.
But last occasion was the only default that I,
Today you are not ready.
lords,
Matter is of the year 2019. 6 years are over now.
no, this was,
When will you be?
lordships, next week, my lords.
But we have older matters now. We have older matters. We can come this matter after 3 weeks at the request of the council, appeals for the committee. Appeal for the accused.
Accused, my lords.
You have made appeal.
Yes, I am.
States appeal against.
I don't know, 15.
There is a state appeal against the accused lords. Lordship, order dated 19/2, lords issued notice. It's my fault that I have not given a notice that to file requisite. So that is, lords, I pray for 1 week time to file requisite to the.
3 days. 3 days granted to accomplish the failing which appeal may be dismissed on that ground and indication to the government. Yes.
Item 16.
16 also state the appeal against the accused. Yes. Let's
Since
see.
you honestly said that there is lapse on your part,
Yes.
we have given 3 months.
Let's say the 186 days delay to file for the appeal. It's an offense under section 376. Bill number 16. Yes. The offense under section 371, T23, 440, 506, 34 IPC. That's, that is a delay of 186 days. Yes, there is a eyewitness Miller's.
Sir, steps are not taken.
No, Miller's, it's not, notice has not been issued in the limitation section.
This is 16. It was issued. But that's
15.
on order number 1, I 5th of March. You can look at the list also.
Yes, yes. That is, sorry.
Yes, so it has been solved on.
Delivered and received from the postmaster, not
Registry
appeared.
has to answer the question.
Not appeared.
What our friends are saying. Served.
Solved, Miller's.
To flag P.
Yes.
Who's also.
Tracking report showing that status of the all applicants delivered.
But he serves.
Yes, not, nobody is appeared.
This is also to police in this thing.
No.
But
Notice go to the
Since you have speak.
respondent. Speak. Yes. I'll take fresh notice.
no, you also committed already commanded notice and keep it inside. So we can send police petition. The records reveal that the process sent to the Postal Department is served on the accused respondent accused. First one. However, they have not chosen to turn to the court. Whatever be the reason. First, to alert them, the registry is directed to send a police notice immediately. First, post after service. Necessary steps to be taken by the learned public prosecutor. Is the examination public prosecutor?
Yes, that is notified.
Yes.
So this is to the registry.
Yes.
We would have to directly send it. To file the records in registry.
Whatever you should do, that report should be, go and do that.
Item 17.
That other day that job contract for employees that pension.
State is.
Within the
The rule you read.
that particular rule that
No, they are
is
qualifying service.
qualifying service. So far we are paying the minimum pension. It is amount in 10,000.
What is the?
Others matters are the now it is 3 matters. Other 3 matters are
And
also.
item now 20 is similar.
Yes, so we can decide these three matters so that we can bring the same order in those matters.
Yes.
But it may be taken up some other day because it needs, because in the meantime, the Honorable Supreme Court has decided in a matter. I have got the copy, Miller, can have a glance. Therein also,
But you can stand that you are modifying it or Supreme Court has said.
Honorable Apex Court has.
Saying
It's on merit.
It's on merit, but it has not been, it is kept open. Fact remains.
Kept open.
Exactly.
Then we have to decide.
My lord, I have go. And in the meantime, though the person has approached in late,
But generally, in all high courts in the country, when bench complaints of two copies are used. Printed.
no, my lord, I'm sorry, all the, no, please, I'm sorry.
Unless you have no love for me.
No, that's not a lot of.
So what is there inside? Issue here is, as I understand, cursory,
Agent.
where regularization of service is effective, while computing the terminal benefits, what should be qualifying period?
Qualifying period.
According to you, qualifying period is to be reckoned from the date of regularization.
Regular. Yes, sir.
But your rules say other.
Allowing that second copy of the first title.
Give us a moment.
Is it a work charged employee or job
My
contract?
job contract.
Job contract. Kindly read para 12. Do you have copies?
My lord, I two copies I have.
Okay, so
I make many sorry.
one copy then we read together. Myself and I.
You take it.
Here is work charged.
What? No. Job contract.
If we work charged, full service has to be taken. If job contractor, need not be.
Only that regular establishment from the day of that induction. And
When just give us foundational facts. When you
my lord,
entered
the present petitioner he entered into service in 1978.
1978,
Exactly. 24/11.
24/11.
1978. Well, thereafter brought over to the regular establishment on 14/5/2012.
14/5/2012.
Exactly. And retired on superannuation.
Once. In the meanwhile, Harvard daily wages case had come into force. It said, those who have put in 10 years,
10 years.
those who have put in continuous service of 10 years have to be regular. What he said.
There is vacancy and against a substantive post. Madam. Here so far.
If you permit a person to work from 1978 to 2012, can you contend that there was no?
Well, so far this job contract employee is concerned, they are under this survey and settlement, madam, and they have been paid from the contingency fund, madam. So whenever they have brought over to the regular establishment since 2012 and attaining the age of superannuation, retired. Okay, it's a judgment.
Those who were others who were appointed in 1978, did you regularize their services earlier than the regulation of the basis of the responsible one?
Other than
Not be choosy in regularizing. You will regularize one set of employees who will vote for a particular.
no, my lord, they have not been regularized.
Who has to find an affidavit? If you have regularized any of other employees before this, see, you have taken 88, 98,
2008,
2008,
2012.
or 34 years you have taken for regularization. This is very big. This is very big. This cannot happen because state has to act as a model employer. This could have happened perhaps in East India Company, not here. 34 years for regularization. did you regularize the services of any of similar employees
Similar employees situated in the
within a period shorter than 34 years? He was punished. Why he was not regularized?
that I will
But
come to now.
learned government advocate,
Yes,
additional government advocate for the appellant submits that under the extant rules relating to flood or terminal benefit, including pension, only the qualifying service is noted, and that the said qualifying service is reckoned from the date of regularization of employees of the kind. First, he further submits that in the case at hand, the respondent employee gave entry to the service on irregular basis with effect from 24/11/1978, and that his services came to be regularized with effect from 14/5/2020. First, simple arithmetics tell us that the state has taken 54 years for regularizing the services of this employee, and that he retired from service on attaining the age of superannuation on
31/5/2012.
31/5/2012. That means he was regularized
15.
only for a period of 16 weeks.
16.
16 weeks.
And also getting minimum fees.
And accordingly, his qualifying service is computed, and that he is getting minimum
fees.
first. However, matter is not as simple as sought to be made out business. First one, the apex court in Bhupen Hazarika versus State of Assam said that the government had to conduct itself as a model employer. Constitutional mandate being that way in the directive principles. First, court wants to know whether any other similarly placed employees got their services regularized within a period shorter than that of the respondent employee. This information needs to be furnished on an affidavit by the principal secretary of which department?
This is revenue.
Principal secretary. Is there a post of principal secretary?
Yes.
Principal secretary.
Chief Secretary or Principals?
Principal secretary, Department of Revenue.
Revenue.
Department of Revenue, Government of Orissa.
Revenue and disastrous man.
Huh?
Revenue and disastrous man.
Not disaster. He said disasters. Disaster management. Revenue and DM. Disaster management.
Perhaps your case also will have disastrous effect. Yes, Department disaster management. Information now sought has to be authentic and on the basis of statistical record, including the seniority list, if anything.
Because you have been maintaining this.
It cannot be 34 years, I tell you. And there is one judgment where regularization takes place after a long period. That has to be treated as a regular period. There is just such a judgment of apex court. Yes. When are you punishing?
In respect of the job contract.
All right, bracket me. Similarly placed employees, that is job contract employees.
All right.
That means that only. That will be clarified.
Very well. Nice.
When you find that anyone other than this job contract, you can point out.
That's right.
This information you will send when?
4 weeks.
4 weeks. Where your government is? Where your government is?
Government is at 30 kilometers.
On this matter for compliance on 24, first stop. If a report is not filed in time, the personal presence of the principal secretary,
24 July.
June.
So more time.
What? Why more time? It is all on the computer now. Why more time? We are not asking you to launch a rocket. We want this information which is at your fingertips.
That's car festival and other things. I prefer only more time.
Therefore, before the festival only you give that.
Okay.
After the festival.
I should not pray for another time. By that I can.
4th of July.
4th of July.
4th of July.
Pardon me.
Yes.
4th of my difficulty.
You have difficulty.
7th.
7th. All right. 7th of July. First stop. Non-compliance of this order shall be viewed very seriously, and personal presence of the principal secretary may be ordered. Okay.
So far in the today's board, other two matters.
Share a copy of this.
Kindly tagged up.
We'll do that. Share a copy of this, carbon copy of this order with the learned AGA. It's okay. It is also open to you to give that information to us. One more sentence before that. It is also open to the respondent employee to furnish necessary information in this regard.
With 2 copies. And also the High Court order.
Because this matter, along with those two are there, na? Serial numbers?
20.
20. In the meanwhile, you have to bring that judgment. All right. That judgment is by Justice Paripurnan.
Yes, Paripurnan.
Or any information also they can share with you. It will be convenient to apprise this court. Today it's a violation.
He is not your enemy.
No, not that way, ma'am.
I do.
For the appellant matter and challenge of the order passed on single judgment. Last occasion, this court issued notice on the question of limitation. There is a 49 days delay in the filing the writ application.
29 days
Delay in the filing of the writ application. Due to illness, the doctor advised not to move it. 49.
29 days.
49 days. 49.
It's not we control of the immediate ground of guilt. Person, the application accordingly is more supported by an affidavit. Matters like this. Next, applications dealing stuff.
Next week.
Not ready today.
This is the material list on heading of orders.
Next, the 2023 matter.
Well,
We could get the request from the beginning for the respondent.
on Monday, ma'am. Monday.
Monday we have difficulty whether we have pushed it other.
But Tuesday next week.
Yes.
7:21.
Yeah. How many days?
59 days.
59 days.
My learned friend has also appeared in this case.
No objections are filed. We handle the delay. Okay. Not needed. Plus.
I have also served a copy of the writ appeal of my learned friend. Let me fix it to next week candidate for admission.
Why the time of donation of the legally will not give
No, notice was issued on only limitation petition. Yes.
But the Supreme Court says, while controlling delay, merits of the main matter is one of the important
Yes,
factors.
yes.
Therefore, you should have given that also.
Yes, ma'am. So, my
You have solved already.
yes, today I have served the copy of the copy. Yes.
You ask, he can ask time, not you.
No. I mentioned because I saw then
Let's see if he is ready. Yes.
I am for the
You're
respondent,
for-
private respondent,
Are
sorry,
you ready
private.
to comment?
No, lordship, any other.
On this point, when choose a date, that date we have part to the matter.
you know, fix and then I
So fix a date, take a date.
and on July birthday, I don't have any objection.
They are not that beautiful. Writings are not, readings are not that good. Nobody reads the readings by Moga, readings by soldiers. Just write me every story. I read this point. Yes.
Item 22.
52 millers, matter relating to the regularization millers. That limitation is millers 27 days delay.
627 days. Why so much delay?
As I explained in the
What is on merit?
merit millers, that is not recruitment process has not been followed, not in proper advertisement millers in terms of the human case millers. So that is only ground millers. Recruitment process has not been followed, no advertisement. The president of Consumer Forum has been appointed the petitioner as the peon.
He had no power to appoint.
That is
He has the power to appoint. There was a throughout Odisha, there was an advertisement for pursuant to which the petitioner and the other employees they applied. Advertisement, my lord, that is for not be with me at present, my lord. But here is a case, my lord. So lordship will find, my lord, this case. In Sitaram Bhoi case and Deborah Sahu case, the Honorable Apex Court has confirmed the order in respect of these exactly similarly situated persons on the basis of which the order has been passed. Your lordship may kindly look at the order passed in the
Read the Apex Court.
basing on the decision of Supreme Court, the order copy which is impugned in this case. Yes, ma'am. There,
What Supreme Court judge you are saying in your favor.
no, that is not with me, my lord. But your lordship may kindly come to paragraph 8 of the impugned order. The Supreme Court judgment which when you actually Supreme Court judge. Yes, ma'am. But here thereafter, my lord, I filed a contempt petition. Contempt petition was disposed of.
Why can't you understand people in English, sir? Do you want to give us copies of the judgment, sir?
That is not with me here.
Who should go? Tell we'll go and ask.
Because
It is never duty. One said it goes there. If you want to act on certain decision, you are bound to furnish the decision. So that's right to the other side. If you are giving away here, otherwise how to talk to the rest of them? If you say, I do not have copies, can we go to Jagannath and ask for the copies? How?
We are here to help you, provided you give us the material. That's very important, na?
yes, ma'am.
Then, you know, how can we? Therefore,
But yes, High Court judgment.
Sir, I'm going. Never saw you as twice you have said two days.
No, they are my lord.
That you are one day or two days you have decided whatever you will say.
Because it is their appeal, my lord. They after disposal of that.
Petition. No, I'm asking. The petition. You have relied on those decisions.
Yes, my lord. That has been reflected at paragraph 8. Your lordship, the
That order is in challenge.
that order is in challenge, my lord.
The law of appeal is when order is put in challenge, ordinarily what is stated in the order cannot be taken as a possibility.
No, that is correct. But they have referred to that at paragraph 8. If your lordship will kindly look at paragraph 8 of the
We have read the papers.
yes.
We have got the midnight oil. But what
But
says,
because it is
you're not showing courtesy to this.
but because it is on the question of limitation, therefore I did not get myself prepared, my lord.
Then we will come down the need.
No, my lord. Your lordship may kindly look at the petition, my lord, delay convention, how they have explained, my lord. And in the similar situations, 2 writ appeals have been dismissed and they have complied with the order, my lord.
You have complained with
Yes, my lord. 2 writ appeals have been dismissed on this ground, my lord, on the ground of limitation.
Direction of the
I
Supreme
am
Court.
having
I have stated in my ground number D, Miller, not similar to the Sitaram.
no, it is similar.
But you are relying on Sitaram, you are not showing anything.
No,
You are
the,
saying that it is their appeal, so I will not show any. That's your sense.
because it is on the question of limitation, therefore, my lord, my lord,
No, 30 years to this. Because we want to help people.
I
We
understand.
may not help.
It is my fault, my lord, I could not trust.
Yes, sir. What is the explanation for the delay?
Paragraph 4, your lordship.
That's.
Paragraph 4 means
Of your application.
application. Miller. IN number 3547.
Page number.
Page now 2 of the internal page, 2 of the limitations.
Column number.
4 Millers. They decided in the meeting that is such and such held under the chairmanship of
When
secretary.
the order was made.
Order was passed in the year, my lord, on 3/8/2022.
38 to 22.
So, the meeting dated 18/12/2023 of the Parliament of the Council, when when did you file the appeal?
It's filed on 16/5/24.
17/5.
17/5 presented 17/5 24.
22.
24.
4 months.
24.
Yes.
38/22, 17/5/24.
24.
2 years.
Is it the Keshavananda Bharati case? What is there? So much time for filing the appeal.
So only explanation given in para 4, not more than that.
Well, he's rightly telling us. It's not the case for resolution of.
The state opinion.
The state it does not stand.
Liberally, Miller.
It's an ordinary litigant for us as any other citizen. That means, listen, the state should be more vigilant. Almost 2 years if you find the appeal, what should happen to the party? Is it not? Please be seated. While now it's sit down. This interpret the key by the state seeks to call in question a learned single judge's order. April 4 of 2016. Next one. Appeal is filing of the brooking a long delay of
623 days.
23 days.
27. 27 days.
Yes, sir, going there. Yes, sir, going there.
647.
An application supported by an affidavit accompanies the same, seeking continuation thereof. First, after service of good deeds, the respondent employee having entered appearance to his own self, has filed the objection to the said application, and the counsel vehemently opposes the prayer for continuation of the contending that delay is too long to be condoned, and that the explanation offered for its continuation can never be said to be plausible. Going by the text, more particularly, para 4 thereof. First, per contra, the DGA submits that state stands on a preferable pedestal when request for continuation of delay is treated, and that continuation of delay would not add merits to the case in appeal to the disadvantage of the respondent, and therefore application be allowed and delay be concluded.
First up, next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter because we do not find any merit in the application supported by the affidavit whereby condonation of long delay is sought for. First up, reasons for our view are not far to seek, colon. Firstly, state cannot have a larger status and a larger preference than what an ordinary litigant would have in a constitutionally ordained welfare governance. First up, state is more often than not an ordinary litigant. First off, the officials of the state have to be vigilant, at least when it comes to court litigations. First off, that is lacking in the case at hand. First off, next paragraph. Salmon, in his jurisprudence, and in Salmon's jurisprudence, by Fitzgerald edition, says that law of limitation is a law of repose and peace. First up, long-drawn potential litigations would not augur well to the citizens. First up, unless delay is plausibly explained, it cannot be condoned merely because the seeker of condonation is the state or its functionaries. First up, as rightly contended by learned counsel appearing for the respondent employee. First up, state is a mighty entity, whereas the respondent employee is a petty person. First up, even on merits, we do not find anything much favorable to the appellant. First up, condonation of justice would be served more by dismissing the application for condonation of delay, and as a consequence, the appeal as well, than by condoning the delay in the given fact matrix of the case. First, last, in the above circumstances, the application in IA number, CP number, right? IA number so and so, seeking condonation of long delay, being unworthy of consideration, is rejected, and as a consequence, appeal fails.
3547, IA 3547.
Fails. Courts having been reluctantly made easy. Okay. Hereafter, we will be very careful. All right?
Item 23.
May I please, Your Honor? Item number 23.
Yes, sir.
My Lord, it's a writ appeal, my Lord. Fencing of dogs. My Lord, Honorable single judgment, my Lord, this writ appeal has arisen, whereby in wherever, my Lord, my writ petition, which was filed against the removal order passed by the respondent company, has been satisfied.
What order?
Removal order, removal from the BCCL company. The petitioner was an employee officer in the BCCL company, respondent company.
Dismissal of employee from a company.
Removal from the company.
Removal.
Yes.
Not dismissal.
Not dismissal, removal. This particular punishment has been awarded.
This is a penal order.
This is a penal order, my Lord.
After disciplinary inquiry.
Yes, my Lord. And what I'm trying to point out, my Lord, because this petition was, my Lord, there is a delay, crept in 25 days delays, only merely 25 days delay. So I humbly, my Lord, withholded and prayed because in this honorable court, my Lord, delay.
No, your adjectives need not be there at all. Why you should pray? It's your right to argue.
My Lord, definitely, my Lord, since honorable, the Chief Justice, my Lord, pleased to pass an order to serve a copy, my Lord, well, contesting respondent have already given copy. The chairman. Board
All
of
right,
Directors-
now at this stage you want condonation of delay?
No, my lord.
No delay at all.
I'm ready with the merit copy.
You are ready with the
Because
merits
my-
of the matter?
Yes.
You appear for the respondent.
Protesting opposite parties 3 and 4 and 5.
They are not.
They have notice mail.
No, let me. But they are not the contesting because the reason, my lord. The appellate order has been passed by the chairman board of directors. He received the copy. He is the appellate order, my lord. The original order merged into the appellate order because the appellate order, my lord, that the punishment order has been affirmed by the appellate order finally, and they have already served the copy. And they are appearing. They have put their appearance also. And since matter is very urgent because of the reason, my lord, my petitioner is for the last 2012, my lord, is in road. Virtually, he is on road. On the basis of that, a departmental proceeding, which is fully ignoring all the settled principles of law.
All right, understood.
My lord.
What are the faults in the removal order? What was the charge?
Yes, my lord, Charles, that's fine. But I've prepared a short notes, your lordship.
Yeah.
That I'm passing on to your lordship. But
Please.
a concise short notes, your lordship. 2 copies. Your lordship may kindly have 2 copies, my lord. And 1 copy I'm giving to you. No problem.
Yes. Thank you. I'll move forward.
Yes, my lord. Yes, before I start, my lord, little factual background really important for your lordship and information.
Correct.
Very short factual background.
When did he enter service?
Service 2006, my lord.
1 second.
Yes, as a account officer in the BCCL company.
Kindly
I'm
halt and proceed.
No, my lord, I'm sorry.
In life, that is the best principle. Halt and proceed.
Every day we are learning, my lord.
Yes. He entered service on,
2006,
kindly give the date.
date, to be very specific, 23rd of December 2006 as account officer. 23rd, 12, 2006.
Accounts officer.
Yes.
Any promotion he earned?
Yes, he promoted to the post of assistant manager finance.
When?
My lord, just after 1-2 year, my lord, I have not mentioned the specific date, but he has promoted up to full satisfaction of the respondent.
Only answer, one single answer will do. Promoted as?
Assistant manager finance.
Only one promotion?
Yes, only one promotion, my lord.
All right. What was the charge memo given to you?
My lord, in 2012, what happens? A false case was lodged
No,
against him.
give us the date of charge memo.
Yes, judgment was
Charge memo.
charged memo.
What do you call it in your state? Charge sheet or charge memo?
Yes, charge.
Charge.
It's a charge. What?
Hmm.
Memo on 10/4/2013.
1 second. 10/4/2013.
2013. 10/4/2013 is a reply, my lord, on the charge. And I'm just speaking. And charge was given to him on
26th March 2013.
my lord, I'm grateful to you. Yes, ma'am.
26/3/2013.
The charge was that, my lord. What was the charge about?
Your reply is 10/4/2013.
Yes, ma'am.
What was the charge?
Charge was that, my lord, I may humbly take a little pause there because I just stated that a false case was lodged against him. Why false case? Because
What is that false case?
false case that one petty contractor alleged against him that he used to process a tender file, he demanded 20,000 rupees. Then CBI trap case was laid and he apprehended. But I've just stated it is a false case because
1 second. See, there was a allegation of bribery.
bravery.
1 second.
Yes.
Whether the pink test was conducted,
Pink test was conducted.
how it was, what is positive or negative?
It was positive, my lord. It was positive.
1 second.
Thereafter what?
1 second. When raid took place,
Raid took place in 2012 itself.
you have to give the date.
Yes.
On which date it happened?
20th of August 2012.
Read by whom?
Read by the CBI officer.
CBI.
Yes, on the instance of the complainant himself.
All right. CBI on
28th August.
28/8/2012. Pink test proved positive.
Yes, thereafter what happens, my lord? I'm
So we have to process.
Yes, yes.
This is argument.
Yes.
We have to process every sentence.
No, you are aware of the prosecution. They are the court.
Yeah, prosecution.
No, kindly just listen the query. When my lord is asking you that the pink test is positive,
Yes, yes.
the learned trial judge
Yes.
found that the pink test is positive.
Positive and convicted also. But that matter.
Correct. No, please. Please, again, I'll reiterate what my brother has said.
Yes, yes.
There was a criminal case also.
Criminal case also? Yes.
You just give us binary answers.
My lord.
Unless we elicit some
Yes.
more.
Yes.
Okay?
Yes.
Criminal case number?
Criminal case number, just a minute. Since it's a subject matter of this one great jurisdiction, Malad. $19,812.
What is that? Criminal appeal, case, CC, what is that called in your state?
Criminal case number 130. 138 by 2019.
138
by 2019.
by 2019.
19.
Before the special court?
Before the special court CJI.
Is it under section
Yes.
13?
13, 7, 8. PC8, my lord.
What happened in that?
In that case, my lord, in that case, the learned trial just convicted the accused person, accused petitioner, delinquent, but
Convicted on?
just yes. Convicted on 21/1/2019 by the CBI Dhanbad in RC case number 19-1, 19A, 2012D.
Sentenced to? What was the sentence?
Sentence was that 3 years, my lord. RI put 3 years. Sentence is for.
Any fine?
Yes, fine was also involved, my lord. Yes, madam. Fine was 50,000 fine.
Have you paid the fine?
Not much.
Not paid.
Since we prepared an appeal before the Honorable High Court of Jharkhand.
Appeal, criminal appeal number?
Criminal appeal number 138 of 2019. Criminal appeal single judge 138 2019.
Criminal appeal number 1? Criminal appeal
Criminal
number?
appeal single judge number 138 2019.
Your criminal case is also 138.
No.
Huh?
Well, since
You said criminal case 138.
No, I'm extremely sorry. Criminal case number. Kindly, please. I'm getting confused. Criminal case.
Be slow. Don't have anxiety.
Yes, my lord. Criminal case number RC number 19/8/2012. Criminal case number.
Criminal case number?
RC number 19 capital A.
19?
Capital A. Under bracket 2012 D.
2012.
12 D. Yes. In the CBI court, Dhanbad.
This is criminal appeal is 138.
Yes.
2019.
2019 referred for the Honorable High Court of Jharkhand.
What happened to that criminal appeal?
Honorable High Court of Jharkhand pleased to pass an acquittal order in favor of the petitioner. And
Is it honorable acquittal or acquittal because of want of evidence?
want of evidence, benefit of doubt was also given to them.
Benefit of doubt.
Benefit of doubt was given to them. And thereafter, my lord, another writ petition was filed because this subject of this writ appeal is arising out of 2 writs.
When writ appeal was allowed, criminal appeal was allowed?
It was allowed on 31st of July, 29th of September, I'm sorry, 29th of September 2020 by the Honorable Jharkhand.
2020.
Yes, 2020, 29th of September 2020.
Do you have copy of the order?
Yes, my lord, it is already tagged in the second writ application, which is already on record.
Second writ application. What is that second writ application? Perhaps this matter will take some time. Your friends can go for a coffee round if they want.
My God, since that is why I.
You are saying second in the sense in the list today or not read the list?
This writ
Have you look at the list?
This writ has arisen out of two writs.
No, you are not getting the question, sir. Whether the order what we are referring is before us, what is the serial number or whether it is tagged, that we are asking.
It is tagged, my lord. It is tagged.
Which number? Writ petition?
It is writ petition number 18538, public 2021.
So this is the writ appeal arising out of that writ petition.
Yes, my lord, two writ petitions.
One writ appeal, two writ petitions.
Yes, two writ petitions. First writ petition was filed in 2016, challenging the removal order of the delinquent, my lord. And second writ petition was filed post-acquittal stage. That is numbered as 2021. So therefore, impugn order has been passed in two writ petitions. On the basis of two writ petitions has been passed in impugn order, and both is under challenge.
1 second.
There has to be two separate writ appeals.
Separate. What happened to that writ petition?
Which writ petition, my lord?
See, you said
Yes.
you had filed a writ petition challenging the penalty order of removal.
Removal, yes.
That writ petition.
Yes.
What happened to that writ petition?
Both writ petitions are heard together because both the
Another writ petition is what?
Another writ petition was second writ petition was filed after acquittal stage. Once the petitioner was acquitted by the Honorable Jharkhand High Court, then he preferred another writ petition challenging that since I have been acquitted, I will be reinstated in service. So both writ petitions will be tagged. And the Honorable single judge heard the matter, both the matters were heard together and
Common judgment.
Yes, common judgment has been passed.
But at least, ideally speaking, two writ appeals should have been filed.
The cause of action is different.
Different. Because disciplinary inquiry is one thing.
Yes, one thing.
And it proceeded separately. And
No,
completed prior to acquittal in 2014.
My point before the Honorable single judge.
That was lots of punishment order. Punishment order removal is dated.
My moot point before the Honorable single judge.
2014. Much I am here. 2014.
Removal.
No. The inquiry report is 14/8/2014.
Inquiry report.
14th of August 2000.
And removal order. Removal order is?
It is 23rd, 12/2014.
After your criminal appeal was allowed,
Yes, my lord.
you requested them saying
Yes,
that we have not completed our sentence. You requested the management to reinstate you in service.
Yes.
On the basis of acquittal order.
Yes, my lord.
Where is it honorable acquittal or acquittal on technical points or for want of evidence?
For the language is the benefit of doubt was granted.
Then it's not.
Yes,
take
yes.
out the
I'm not- yes.
PV,
Yes.
WPC टा टिके खुली हुई.
take out PV Rudrappa versus State of Karnataka of Karnataka High Court.
Yes.
We'll get down the road of Google.
But may proceed.
Rudrappa, are you DRA?
PV Rudrappa, are you DRA PPA? PV Rudrappa versus State.
Versus P.B.
Take out that judgment.
DRA PPA.
Yes. But my point. Yes.
Second, we have.
Because that's I wanted to say, my lord, I am not on the point of acquittal.
You're not on the point.
No, certainly not. Honorable Single Judge therefore erred in holding that I have challenged the only writ applications on the basis of that I have granted acquittal. No. My point before your lordship kind consideration was in the writ court also that I have been removed after entire procedural lapses have been done. Why? Because the inquiry has been conducted by an incompetent officer, number one. Number two, even the complainant has
under the rule, who is the competent?
Yes, competent officer is the
Givers.
yes, my lord, just under the rule.
Let us go slow and pleasant also.
Yes,
we have to be pleasant also.
My lord. Yes. Your lordship, this rule copy, my lord, only one copy I have, and I will read, my lord.
Why your body is so frugal? You don't call the judges for coffee,
My lord,
and you do not give the
Other
copies to the judges.
I am very sorry, my lord, since this was the, I tried to.
And this plea you took at the earliest.
Yes, my lord, very first writ.
No, not read in the proceeding when
In your
objections.
objections.
In your objections.
Yes, objection I also taken that the incompetent officer has been held, has been made an inquiry officer, and it was turned down.
Where is, go to your, you had filed a reply to your show cause notice.
Yes, my lord.
Where is that?
Yes. This is in my lord, read number,
Read petition.
read petition number
18,538.
17,035 of 16.
That is not clear. I think you are not following the cause list.
See, did you take up contention as to lack of jurisdiction
My lord,
competence?
Yes, my lord.
At what point of time?
Lack of jurisdiction with regard to competency of the court. Yes.
Disciplinary authority.
Yes, my lord. So page number 32 of the writ, my lord, of the writ of 2016.
No, in
So
writ
first-
appeal.
Yes,
Page number?
not writ appeal, my lord.
So
Writ petition, which is that.
That read is not with us.
It's not a part of the paper.
Wonder. You are the briefing. You are.
Yes, ma'am.
So you please point him out that where is the read petition?
Yes,
Because only 18538 has been listed before us.
Yes,
Then where is the other 117?
17035/16.
So in this 18538, whether you have annexed the copy of your reply,
Yes, my lord.
page
That actually tell
18538 in the disciplinary proceeding or the DE. Have you enclosed your reply?
my lord, after being acquitted of the charge.
No, sir. It is 2014 matter, sir. You are acquitted long after 2014. Correct.
29/9 by
So
20.
Lordship asked him, I'm sorry, your name,
Ashok Kumar Pandey, ma'am. Ashok Kumar Pandey.
Pandey. So, are you sure that you have annexed that in the writ petition
Yes,
18538?
No, 183.5, it is
You are not having that. You are relying on some.
it is annexed in the first read, my lord. Which is already on record, my lord. First read, that is 17.
Sir, by saying that where it is now located in the, it has to be before
Yes.
us today.
This,
Whatever you want to say,
my lord.
the answer to that or question arising from that should be relatable to the papers at the hands of the judges.
Yes, my lord.
We are not finding those papers.
My lord, yes, my lord. In the read appeal, this is not annexed. It is.
Then how you can
Also the writ petition. The writ petition 18538, it is not there. We are having copy of writ petition, both of us.
Yes, my lord, I am having the copy of that.
where have you stated in your petition what all the documents are?
My lord, it is stated in the read number 2016, my lord.
No,
The first
please understand. To your show cause notice.
Yes.
How disciplinary inquiry is initiated.
Yes.
Show cause SCN, show cause notice is
Yes,
given
my
to
lord.
you. You send your reply.
My lord.
Then they frame the charge sheet,
My lord.
charge memo.
My lord.
Is it not?
Yes, my
Then inquiry is held.
Yes, my lord.
Then report is submitted
My lord.
to the authority.
My lord.
Copy is given to you.
Yes, my lord.
You will file representation to the report in the right of Ramjan Khan decision.
Yes, my lord.
All that will be considered by the competent authority,
Yes.
and penalty order or exoneration order will be handed.
Handed.
Correct?
Yes.
That's the service law.
Yes, yes.
Now we are asking you.
Yes.
When you took up your contention that the disciplinary authority, any authority who had issued the show cause notice to you was incompetent.
Yes.
Where is that?
We have
From the papers we are holding.
Yes, my lord.
From this you should show,
I'm
not something elsewhere.
Yes, yes, yes. But I must be very fair, my lord. In the writ appeal, this is not annexed. In the writ appeal, it is not. I have annexed only this much that I can try to show.
All right. Do you have any papers with you?
29.
Yes, yes.
Can you see writ petition, page 29.
That's the first writ petition.
WPC 29 face to face. No, you don't have to find it over.
We'll have it. We'll see this. Wait,
Whatever
here.
is there here, we are looking at it. Let's
Yes, yes, my lord. So therefore, my lord, I
Summary of
think-
what he has said. ये what's in 28. 28 का लिखे scroll up करो. Last part. Scroll. इतने नो फरक. And whereas. देखो बड़ा करंतु. Make it yes.
You only denied charges.
I deny the charges, my lord.
Scroll down. Scroll down further. Next page. This see this. We are dealing with this. Yeah, my God, for recommendation and he was given an opportunity to make this recommendation on the report in very exact. Next. Report of improper in which IA did not supply the copies of documents and foundations managed to put the amount of resolution was for other purposes.
So you accepted that you had received the money. Your stand was it was received for some other purpose, not in connection with the job.
What, my lord, that is, yes, that is there, my lord.
You have said in writing.
You said, my lord, that is, yes, my lord, whatever is on the report, my lord, I cannot change this.
Correct.
But I am harping on the point, my lord. What I am trying to point out in the writ petition number 216,
yes.
My bone of contention main argument is itself
that
yes, there are certain law, my lord, why that I cannot challenge the decision. But I certainly can the decision-making process if it is vitiated by the non-consideration of material witness, number one. If it is vitiated by the principle of natural justice, non-compliance of personal responsibility.
Yes.
Number three, if the inquiry which was conducted by the inquiry officer, he himself was not competent as per their rule and guidelines. The Coal India Disciplinary Authority Rule 29.2, I must be very specific, 29.2 says...
No, where have you taken up that contention?
Contention I have taken or not? Your Lordship may kindly see, if Your Lordship may...
Pandey, actually...
at the earliest of point, see...
Mr. Pandey, you are... maybe you have to... We'll call for that repetition.
Well, now only because we are halfway through. Get that repetition.
WPC? What is the other WPC you are referring?
Yes, WPC number 17035, 17,000.
Bit slow, they will record it,
yes.
Go to the registry, or if it is scanned, then you can get it.
17,035, public 2016. This is the 40.
Date of disposal. It's relevant because now...
Date of disposal 31/7/2024. Both the writ petitions were decided on that day.
Yes.
And second writ petition was 18538, public 2021.
18538 is available, that we have been telling you since beginning, but the other, since you have started referring to the other petition,
yes,
it is not.
But I'm very extremely sorry, but it is not happily worded, Manat, since I am not.
That's all right. We have no problem with word
outside.
No problem there, but
yes,
we must ensure that it is listed.
Yeah, definitely, Manat, I'm grateful to Your Lordship.
Yes.
And my point
now you formulate your contention.
Yes.
Yes. Contention is?
First contention is that the inquiry officer was not a competent officer as per their rules. Coal India disciplinary rules.
Incompetence.
Incompetent.
Number one.
Yes,
which is the rule?
Yes, rule says so.
Just narrate one point. You said that incompetence.
Yes.
Number two.
Number two that the complainant has not been examined by the inquiry officer. So therefore, since the author of the crime has not been come to the witness box, so therefore the petitioner did not get any opportunity to cross-examine him, meaning thereby there is a gross violation of principle of natural justice because he was prejudiced. He himself is the author of the crime.
So your second...
Mr. Pandey, did they produce the witness and examine the chief?
Yes, sir.
So you were denied opportunity to cross-examine, or you did not cross-examine?
He was not cross-examined at all.
Sir, you are not getting the question. You are not getting the question.
But he was examined in chief.
Are you sure he was examined
as a witness?
As a witness by the prosecutor, by the presenting officer?
My lord, he was not examined.
Then
he was not examined.
Then it was your duty to call him as witness.
My lord, there is a judgment of the Supreme Court.
No, kindly. There are so many judgments, we may not know, but don't be fast. You are on top of your brief, but you are not answering. The Supreme Court nowhere has said that this presenting officer should invite the person to examine, because you see, they have not invited and examined him. They have not relied on that.
Yes.
That could be your argument.
Yes, ma'am.
That though they did not examine him, but still they are relied on his version.
Yes.
They have gone on the technical part, that whatever was recovered and what is your stand. Suppose you wanted to produce him as a witness.
Yes.
Then you can call him. They may refuse it. So that vitiates.
Yes.
Because your requirement of producing that witness was denied by them.
Yes.
So these are from the day one when it started. And you are, I think you are not very sure that whether he was produced by them or called by them.
No.
Show us who are the witnesses examined.
Yes. And that second May I proceed first?
The first one you said competence.
Competence.
Second one you said the star witness was not examined.
Not examined.
Number three.
Number three, that entire material witnesses has also been not examined. There is also judgment on this point also.
That's correct.
Yes.
We also know little law.
Yes.
We have not come from kindergarten.
No.
We practiced for long
I even
period,
cannot dream
even
of
on
such.
service law.
Yes.
Then we came to be appointed, whether willingly or unwillingly.
Yes.
Therefore, on law we will go.
Yes.
Facts you tell.
My lord.
Facts we tell. We'll take your assistance
Yes.
also.
Yes. And
So, material witnesses have not been
not been
examined.
examined. Yes, my lord. Thirdly, my lord, that the petitioner was not given the second show cause prior to the infliction of the major punishment, which is also
Second show cause notice to be given.
Yes, my lord, as per their rule also says so.
No, after 42nd amendment to the constitution,
Yes, my lord.
that is taken away.
But their rule still says so.
Whether rule is superior, constitution is superior.
Definitely.
But then what is that?
Then I will not take that point. I will not take that.
So only 3 points you are urging.
Yes, my lord. So the inquiry officer he was not competent. So if the
Now let us go to at
Yes.
what point of time
Yes.
you raised the issue of competence?
Yes.
At what point of time?
My lord, in the appeal itself, in the appeal also, in the
Not in appeal.
in the that
The
appeal.
objection as to the competence has to be taken at the earliest point of time.
Yes, my lord.
In service matter, that objection has to be taken even when it goes to the root of the matter.
Yes, yes, my lord.
Unlike in the civil disputes.
My lord.
When did you take up, when you were given the show cause notice,
Yes.
you said that show cause notice was given, that date you have not given. Charge memo you gave, 6/3/2013 you gave the charge memo.
Showcase notice was given to me on 26/3/2013. 26/3/2013. Showcase notice was given.
2014.
13. Yes, one.
In your reply to show cause notice,
Yes, I replied.
did you say
Yes.
this show cause notice is by incompetent authority?
Yes.
Show that. Read one line.
Yes.
In the meanwhile, get that P.V. Rudrappa was the state. Get that judgment. This is the formula.
Where have you taken us?
Yes, my lord.
When did you send your reply? Give us the date.
Yes, yes.
Others can have a round for 10-15 minutes because we want to complete this matter. You are entitled to sit in the court hall happily, but you are at liberty to leave. You are not captive audience.
So they're captivated. Actually, put suggestion. We don't put it.
You are not even dismissed. You are only, it's a removal simpliciter.
Yes, removal simplicity. Removal simplicity. But that is a major punishment.
That's all right.
Yes, sir. My lord, I have taken the specific point in the, my lord, appeal referred before the appellate authority.
No, that is an afterthought. Earliest point of time
Yes, my lord, just trying to.
you have to take. You can't become wiser after the time passes.
Yes, yes. But since.
And Mr. Pandey, since you have raised this issue of non-examination of a witness.
Yes.
In your SOCOs, you have said Sri Sarkar on whose drawer the file was taken has not been examined. You should have stuck to that. Because Sugreep Singh is the alleged provider of the bribe money. You have never said about Sugreep Singh.
No, he accepted receipt of the money.
That's the problem.
You accepted. You accepted that you accepted the money.
It was trap, Malad. It's a trap.
Whatever.
What is that?
I mean,
What
your
is-
explanation says that I accepted it from Sugreep Singh, but it is for a
And then
different
so-
purpose.
Ah.
That is the reason.
Yes,
he was not
They were
exact.
smart enough not to call Sugreep Singh.
Where was the need? We could accept it.
That's factually.
And there is one more point. May I?
The first point you have to take now.
Yes, Malad.
Now you are very slow. You were very fast earlier. Now you are very slow.
Since Malad, I have got the SOPOS, but SOPOS I have not specifically mentioned, Malad, on the point of competency.
You have not mentioned. You are replying.
I have not, in reply, Malad, I have not mentioned.
Reply is dated.
Reply is dated, Malad. I have got the reply.
14th of April 2013.
14 and 20. No, report it is. 14th of April.
After 26/3.
Okay.
Date he has not given, Malad.
It is dated 14/4/2013.
14/13.
Yes.
Because in the
10th.
10/4.
10/4.
10/4/2013.
13.
Read, let us read that. We will know everything now.
Yes, Malad. May I read, Malad?
Yes.
It's a part of page number 30 and Excel 5 of the first writ petition.
30.
Sir, that is what I-
30, Malad, in the first writ petition.
Yeah.
That is not on the record.
All right.
May I read, Malad?
Yes.
Yes, Malad. It's a 3-4 pages, Malad.
Only relevant points on this, whether
I mean,
he had competence or not.
to support your summation regarding Sugreep Singh not being called.
Yes, Malad, to be very fair before this honorable court, Malad, that point he has not taken in the.
Not taken.
He has not taken.
You concede that.
But reply to this, Malad,
All right. 1 second. Thereafter, a report came to be served on you.
Yes.
Enquiry report came to be served on you.
Inquiry report, sir.
What was your representation to the
Yes.
inquiry report? Did you take up that contention too?
Yes, Malad.
Yes.
Mm-hmm.
27th September 2014.
Yes.
27/9/2014.
Yes.
Your response to the inquiry report.
Yes, yes, Malad.
Seven, 9, 2000.
Yes, Malad.
Sure.
Connection 7.
Where have you taken up that contention?
Yes, 11/9/2014.
Inquiry report is 11/9.
11.
Your response is 27/9.
Inquiry report is 14/8/24.
Sent to him on 11/9.
So it was sent on 11/9.
Yes, inquiry report is 11/9/2014, right?
Okay.
It is contained in page 53.
On 27/9, you sent your reply.
Yes, yes, yes.
What is that? Where is that contention you have taken up?
Yes.
And be careful, go slow because you may miss
Point.
in a hurry.
Yes.
Mm.
Since there are matter of 2 big petitions, Malad, sir.
No problem.
Different
No
issues.
problem.
I'm getting very slow. I'm reading from the short recital of the case.
No, 27/9, where you have taken this point, that's the question. Asked by my lord.
That's the only point.
What is
Where
the
is read the bill now?
Yes, sir.
Single judge just say things.
Yes. Malad, may I read the Shokos? I reply to the Shokos, matter.
We are asking you,
Yes.
where have one sentence?
Yes.
You have no power to issue this notice. initiate this proceeding. One sentence. Second Amendment, which said no second show cause notice need be given. Which is that amendment? Article 309, 10, 11, 311. Take 311.
So the Constitutional Court, they have not given the Constitution.
Okay. Keep one or two copies of Constitution.
You put Raya Katha?
You have to. Give 312. Take out 311. Keep pursue on constitutional law. Okay. 311. So proviso 2, sub-article 2 to article 311. Provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making representation on the penalty proposed. So it is amended.
Yes.
My lord, the non-examination of the complainant, I have taken the point. I have got the point where I have stated so.
Yes.
That non-examination of the Sugriv Singh, the complainant, and Sri A.K. Sarkar clerk is fatal to the department's case.
Yes.
And charge has not been established.
Okay.
Page 39.
So the competence, you give up.
I'm not giving up, my lord. I'm trying to.
You will try, but the try has to come to an end at one particular point before the court rages, na?
Yes. My lord, I'm just trying to search, my lord. Somewhere I have read, my lord, this point they have taken. But perhaps I am getting confusion in the ability state. He has taken the point, specific point taken.
That makes no sense.
Yes, my lord. Therefore, since your lordship is not convinced on that point, therefore I am not.
Because law is that way.
Yes.
In service lies that way.
Yes.
If a matter goes to root of the matter, issue goes to the root of the matter, it stands on a different weighed on administrative law. Yes. Has treated a separate chapter. Void orders, voidable orders, orders void ab initio.
Yes.
3 topics he has treated.
My lord, I hold out to your lordship. I hold on to your lordship.
Yes.
Uh,
So your second point is star witnesses were not examined by the management.
Yes, and
Number
very
2.
specific, the complainant himself was not
Examined.
Yes. And I will come on the judgment later. My lord.
The third point is
That point also goes, my lord, because of the reason that amendment of
no,
the-
that goes now.
Yes, that goes
That
now.
will not
That
apply
will not
because
take now.
311 that proviso is held to be applicable even
Yes.
to the non-civil servants.
Yes, and the fourth point, my lord, I will take that if the charges are identical and the identical charges the department proceeding proceeded and the criminal case also proceeded, then if the criminal case goes, then my lord, the petitioner may be entitled to get reinstatement. There is a judgment. I have the copy of the judgment. I will just pass on to you.
Is it Ramlal judgment?
Yes, my lord, I am grateful to your lordship. Ramlal judgment. Since the charges are identical, it is not the case that he was.
Yes, go to next point. We have understood.
Yes, yes.
Ramlal is 2024.
My lord, my lord.
Any other point?
Yes, my lord. Yes. And with the point, Malad, with the competency of inquiry, Malad, I will only one point I will raise, Malad, subject to your lordship's discretion, that their rule says so. Their rule 29.2, Whole India disciplinary actions rule says so. That 29.2, Malad, I am reading. Whenever the disciplinary authority is of the opinion that there are grounds for inquiring into the truth of any imputation of misconduct or misbehavior against an employee, it may itself inquire into or appoint any officer of the company or any public servant hereinafter called the inquiry authority. So its rule says so, officer of the company should be appointed as a inquiry.
Or you are reading or
Yes, or
go slow again.
once again I am reading, my lord.
Or is also there, na?
It may itself inquire into
May.
or
It starts with may. It may itself.
Correct.
it may itself inquire into or appoint any officer of the company or any public servant hereinafter called the inquiry authority.
Any public servant.
Any public
Who
servant.
was appointed here?
Retired officer of the company was appointed as a person. Retired officer of the company. So therefore, in competency of
How that has prejudiced you?
prejudice because of the retired officer, their rule says so against it's a contract.
That's all right. The rule is contravened. It's all right. We
Yes,
agree.
my lord.
How you are aggrieved by that?
Agreed because the retired employee, my lord, retired employee.
Did you make a request saying that you appointed retired employee? That is not permissible.
That objection was taken, my lord.
At what time?
At what time? In the writ petition also have
In the writ petition, writ appeal in SLP.
16.
When proceedings he holds, at that time you should say,
Yes.
sir, you are a retired employee. I am making a request to the employer, to the competent
Yes.
authority
Yes.
to change you. Kindly wait.
Yes.
Where is that
This
request?
point was taken, my lord. This point was
Where
taken.
had you taken up that?
Yes.
Not in writ petition, writ appeal, SLP. We become wiser as the time passes is one thing.
Oh, yes.
That vigilance will not come to.
Have you seen, Mr. Pandey, the order appointing the appearing authority?
Yes, my lord.
Which page? 29th of May 2013? Which
29.
page of you may have this here in this appeal or petitions? With other appeal, other if you are getting it.
Yes.
Because in a way that favors the employee because he's no more in the, employment of the employer.
He will be more unbiased.
And
Yes,
he's a general manager.
Yes, but my point was that since it is contravention to their rule, contrary to their their purpose.
You are not very sure that whether it contravenes.
My lord, rules. that's why I read.
Whether it prohibits a retired employee to be employed. So that is how we have to see that. You can see that
Yes, 29.2.
No, 29th May 2013, an order was issued appointing the inquiring authority,
Yes, yes.
IA, as they call it.
Yes,
Have you seen that order? Can you show us that?
yes, my lord.
His own competency on that.
you may find that if you have the entire brief of the DP or the D,
Yes.
I think that 19/3/2000, sorry, 29 May 2000.
29th May 2000.
You are taking exception to the disciplinary authority appointing someone,
Yes, my lord. Appointing someone who is not competent.
or the imposition of punishment by authority who is not competent.
Which is that discretion.
Imposition of punishment, which is not, it is not, this is not my argument. This is not my argument. I will come, yes, I will come later on that point that the proper,
No, please.
yes, I will come that point later on because I will take the point that the punishment is disproportionate also. Disproportionate also.
Even when bribery is proved.
Bribery is
it
not
should have been removed.
because bribery,
It should have been dismissed, but they have removed.
but bribery is not proved because the matter was admitted by the Honorable High Court of Jharkhand.
No, that is on criminals.
Criminal side, yes, criminal side.
It is that, is it your case that the entire disciplinary proceeding waited for the criminal proceeding and the order was imposed like 311 and
Yes.
after conviction,
My lord.
because it's a contract, you have been convicted, so and so, so and so. This is something independent of the criminal proceeding.
Yes, ma'am.
Started in 2014, ended in 2014.
Yes, ma'am.
Much before when the trial could proceed also.
Yes, yes.
It was not ever stayed also.
Yes, yes.
If your case that it was stayed, still they proceeded.
No, no.
If it is similar pattern, it will prejudice Captain in for artillery.
Yes, yes, sir. Cameron case, my lord. This is not my main case.
So now, how can this court bring in those aspects?
Yes, yes.
To wait in the taking.
Yes, so therefore, my lord, I am taking the point of only disciplinary proceedings. Only disciplinary proceeding.
Understood.
Because I am not going on the.
Now we will tell you. The, any other point you want to urge?
My lord, yes. My lord, the 4 points I had point, my lord. Number point number that the inquiry officer was, since I am not finding it in the reply, I have taken the suppose in the appellate stage, my lord, in the board of directors, that inquiry officer was not a competent person. And even I'm pleading in the writ petition, I have.
That's not it. You said enough.
Yes, yes, I am pleading. Yes, sir. And second point, my lord, just I have at the cost of repetition, my lord, I will say that several material witnesses have not been examined. On that point, I will just cite the judgment one by one. And complainant not examined this point also. It is supported by the Honorable Supreme Court judgment in Jai Bhagwan case, my lord. I will just pass on to your lordship, my lord. And
You for the star witness not being complainant not being examined in that ruling.
yes, ruling, my lord. Yes, my lord, bunch of judgment I am giving, my lord, and I am.
One is
Yes,
Article 141 says.
Yes.
Law declared. No. Article 141 is point in such a way.
Yes,
Law declared by the Supreme Court shall be binding on everybody.
every third.
Law repeatedly declared by the Supreme Court shall be binding. That's not the wording of
Yes,
Article 1.
yes.
It's one single judge.
Yes, single judgment. It says, my lord, that the citation is 1999, Volume 8, Supreme Court cases. 1999, Volume 8, Supreme Court cases, page 582.
Read
Para 3, yes, Para 3 I am reading before your lordship kind consideration.
Yeah.
Before us, the sole ground urged is as to the non-observance of principle of natural justice in not examining the complainant, Sri Virender Singh, and witness Jagdish Ram. The tribunal, as well as the High Court, have brushed aside the grievance made by the appellant that non-examination of those two persons has prejudiced the case. Examination of these two witnesses would have revealed as to whether the complaint made by Virender Singh was correct or not, and to establish that he was the best person to speak to its veracity. So also, Jagdish Ram, who had accompanied the appellant to the hospital for medical examination, would have been an important witness to prove the state or condition of the appellant. We do not think the tribunal and the High Court were justified in thinking that non-examination of these two persons could not be material. In these circumstances, we are of the view that the High Court and tribunal erred in not attaching the importance to this contention of the appellant. This is this ruling celebrated judgment passed in Hardwari Lal case. Now,
Just have you examined Hardwari Lal carefully? Actually, when the Hardwari Lal lays down a principle,
yes, my lord.
that if the delinquent admits, then also the complainant has to make an example.
That's not
Because you have to go to that far actually. There can be a proposition.
Yes, provision of
Any proposition is possible.
Yes,
Don't get bogged down.
yes, my lord.
in 1901, Lord Halsbury,
Yes, my lord.
in Queen versus Ledan, said a decision is an authority for the proposition laid down in a given fact matrix, and not for all that would logically follow from what has been so laid down. A decision is an authority for a particular proposition.
Yes, my lord.
Given fact matrix.
Yes,
Small additional fact,
yes, my lord.
or absence of a particular fact, it may be seen,
My lord.
even a blind can see.
Yes, and only ratio is applicable. Ratio for ratio decision.
Ratio, you cannot tell precedent on English law by Rupert Cross.
Yes, my lord.
He says, ratio, to find out ratio, there are theories like Professor Wambach's theory, inversion test, etc. You have to inject a particular fact. In that fact, if the ratio, if the principle remains, then it is the ratio. If you take out a particular fact and the substratum of the propagation passed down, then it will not.
My lord, ratio, my lord.
It will not be ratio.
There is kind of universal applicability.
Universal applicability.
Repeated applicability.
Yes.
Applicability by repetition, it should be.
My lord.
That. Otherwise, it will be fact specific.
My lord. My lord, the next judgment, I am harping on the point of non-examination of material witnesses.
Yeah.
That is cited on
Who are material witnesses?
material witnesses. My lord, only 3 to 4 witnesses are there. List of
Have
witnesses.
you have taken up that contention in your representation to the inquiry before?
Yes, my lord.
Sure.
I have taken these points, my lord. I have taken this point.
That one should be taken at the level of inquiry report.
Inquiry, yes. List of witnesses. List of witnesses. First up, I must tell your lordship that what are the list of witnesses, how many list of witnesses were there?
No, you show it one side.
There, yes.
Then
Then one particular environment.
presentation to inquiry report. You have said the inquiry report cannot be relied upon because star witnesses have not been, important witnesses have not been examined.
This one.
And that has prejudiced your case. Two things you have to say. But examine is one thing.
Yes, madam. Para 15 of my reflect.
Great.
Para 15, my lord, it runs like this. That it is submitted that the charge officer is innocent and has submitted no offense as alleged in the article of charges. The departmental proceeding as would be evident from the fact stated above. To sustain the departmental charge sheet, the PO examined as many as 3 number of witnesses, namely PNP Sinha such and such, Satish Kumar such and such, Sankar Bhatia such and such. Of the above 3 witnesses, MW2, MW3 are outsiders and non-BCCL employees, so are not supposed to know about the tendering process of MSBCCL company. Secondly, no witness on tendering process has been examined. And most importantly, to stop the fallacy of the charge, presiding did not examine Sri A.K. Sarkar clerk, the custodian of the file, whose name revealed in the statement of management witness number 1.
No, when you have accepted the receipt of the money, you took 20,000 rupees and you said, I have taken that 20,000. Think test is also true. For you to explain, there is one section in Evidence Act which Stephen had coined for India, that the fact which is within the special knowledge of a person should be proved by himself. It's a general principle. Though Evidence Act is not applicable to inquiry proceedings,
Yes, madam.
the general principle is applicable. The Supreme Court has said it is a general principle. 106 or 107 of Evidence Act. Give me Evidence Act. a fact, especially within the knowledge of a person.
Yes.
The burden of proof, for example, he gives an illustration here, it's a very beautiful illustration. A person is traveling without a ticket. The burden of proof to show that he was traveling with the ticket is with the person who says, I had bought the ticket. Such illustration is there in evidence side. Yes. When any fact is, especially within the knowledge of any person,
My lord.
the burden of proving that fact is upon him. When a person does an act with some intention, a charged with traveling on a railway without a ticket, the burden of proving that he had a ticket is on him. This is the illustration.
Yes, my lord.
Therefore, when you received money,
It was for you to explain that I received money for the admission of my daughter to college, school, etc., for repairing my car, for repairing my house, for health purpose. That explanation is militantly lacking.
That is the case, my lord.
And Mr. Pandey, just check it, whether you denied accepting.
No, he accepted it.
The problem is that perhaps then the static, whatever will be the advice, legal advice or strategy. So you have to check your, because your contention that material witness was not examined, you being the acceptor of the amount.
You admitted.
You said that I have received the money, but for other reasons.
My lord, yeah,
So
it is a-
thereafter, who is the material witness who could not be examined to prove that acceptance?
It is accepted. Very big question.
So you check it whether you have denied it.
Yes, my lord. May I?
Because it apparently your stand is that for other purpose.
May I read the entire reply, my lord?
No, you don't have to read for us. You have to be yourself convinced to tell us
Yes, sir.
which line or which part you have denied that you accepted the amount.
Yes, ma'am.
Unless you find yourself, then how can we are? In fact, we are not the inquiring authority or not the appellate authority.
I have denied, my lord. I have denied.
Denied what?
Denied that I have taken the source.
No.
In the reply.
In reply, you accepted. It is true that I have accepted 20,000 rupees, but it is for other purpose.
27.
I read that somewhere yesterday.
Page 29.
Page 29. Go to page 29.
Page 29.
Read 29.
Mm. 27/9/2014 is your reply.
Yes, ma'am.
The amount of rupees 20,000 alleged to be recovered from CO was for other purposes. You said that I received money, it was for other purposes, not as bribe. What is that other purpose? You have not explained at all. It's a clear-cut case of bribery. And Section 58 of the Evidence Act says admitted facts need not be proved.
Yes, ma'am. And fact judicially admitted need not be proved.
Need not be proved. Well, not judicially.
No.
The word judicially is absent there. It was there in English law,
Facts and-
but here it is absent in our law.
Well, I answer to this query before this court is. But since the appeal is a continuation of trial. Appeal is a continuation of trial. If
Where is the trial?
trial conducted in the CBI court Dhanbad, and since appeal was preferred before the Honorable High Court of Jharkhand, and since the appeal is a continuation of a trial also.
Correct.
And since in the appellate stage, the matter was set aside, my lord, granted acquittal,
Yeah.
so therefore it deems to be proved that the he was not convicted and that the allegation is false.
Read Ramlal.
Ramlal case.
Yes.
Ramlal case is honorable acquittal.
That is only when honorable acquittal.
Yes, my lord. And the judgment passed by the Honorable High Court, my lord, I will be permitted to read the concluding part. What does it says? How the finding portion has come by the Honorable Single Judge of the Honorable High Court Jharkhand by passing the order of acquittal. My lord, some paragraphs I will be permitted to read, my lord.
Says, Ramlal lays down,
Yes.
when an acquittal shall be treated as honorable acquittal,
Yes, sir.
even when the word honorable is missing in the judgment,
My lord.
that Ramlal is considered
Yes.
by P.V. Rudrappa.
My lord.
P.V. Rudrappa, paragraph 5 perhaps, will give you that judgment. Now, because the law has moved little.
Yes, sir.
Read this.
My lord, may I read Rampal then?
We are giving you Ramlal and commentary on Ramlal also by the subsequent judgment.
And like your lordship. We are additionally satisfied, Parasi,
Yes.
that in the teeth of finding of the appellate judge, the disciplinary proceeding and the orders passed thereon cannot be allowed to stand. The charges were not just similar but identical, and evidence, witnesses, and circumstances were all the same. This is the case where, in the exercise of our discretion, we quash the order of the disciplinary authority, and the appellate authority, as allowing them to stand, will be unjust, unfair, and oppressive.
Evidence, witnesses,
Charges.
Charges.
Now, where have you taken up? Same witnesses,
Yes, same witness.
same charges. Where have you stated? That question arose
Yes, madam.
much after your removal.
Yes, I was removed in 2014.
14.
Madam.
Your trial began in which year?
Trial started 2012 itself.
Therefore,
2012 itself.
where trial was held and he was honorably acquitted, then no disciplinary inquiry. If the disciplinary inquiry is held, you are found guilty and removed also. Thereafter, trial takes place after 25 years and you are acquitted. That is not the proposition available in Ram laws.
So
Go to next paragraph.
Yes, sir. So therefore, this point, my lord,
Go to next paragraph.
Next paragraph.
Law has further marched.
in the other words, when the facts, evidentiary material, and the circumstances arising from the criminal case are identical to those in the disciplinary proceeding, ordinarily there cannot be difference in terms of their outcome.
Correct.
Here the charges are same.
Go to next.
Charges are same. If on identical sets of fact, allegations that are vouched by the very same evidentiary material or witnesses, an accused employee is acquitted after a full-fledged trial, ordinarily he cannot be punished in a disciplinary inquiry.
That question arises only if Paul Anthony comes. In Paul Anthony, where you stay the disciplinary proceedings till criminal trial is over. Only in such circumstance, this proposition emerges. Without stay, if the disciplinary proceedings are held and they culminate into an order of termination, whatever a penalty order, then this judgment will not come to your aid. Go to next paragraph.
In a way, this can be linked to doctrine of double jeopardy, constitutionally enacted in Article 20 Clause 2. The apex court in a catena of decision has applied the same. Even in disciplinary proceeding, example, State of Haryana versus Balwant Singh, 2003, Volume 3, SSC 362. This vital aspect has not figured in the consideration of petitioner's case at the hands of disciplinary authority. Alas, tribunal too missed it. This constitutes yet another lacuna in the impugned order. As to plea of honorable acquittal and its effect on disciplinary action. As a
Five indicia are pointed out.
Yes, ma'am.
Just read one, two, three, four, five.
A, yes.
A.
As a norm, offences are tried in a criminal courts. After the trial, court may convict or acquit the accused. Even at the pre-trial stage, an accused may be discharged too. There may be quashment of criminal cases by the apex court, High Court, and an order of acquittal generally means that a person has not committed the offence for which he was charged or tried.
Yeah, that is not your case. That was the case under section 227, 228 of the CRPC.
Yes, ma'am.
Where no charge is at the stage of framing charge is left out.
Yes,
or proceedings are quashed under section 482 of the CRPC. By this court.
Yes.
That's not your case now.
Yes, ma'am.
Go to the next indicia.
The cloud on his presumed innocence thus stand removed.
Yes.
Acquittal is recorded when prosecution fails to prove its case beyond all reasonable doubt.
Yes.
That is when the guilt is not proved to the guilt.
Yes.
The benefit of doubt given to the accused does not mean that he was involved in the case. But the same could not be established by the prosecution. In criminal jurisprudence, the term beyond reasonable doubt implied in a judgment ordinarily does not imply stigma for the one who was accused. However, that is not the end of matter when the accused, being a delinquent employee, is making a disciplinary proceeding on the same allegation.
Same allegation. He is entitled to, he is liable to suffer the proceeding. Good. Next point.
There is where the plea of honorable acquittal factors. Point number B. The question of honorable acquittal is easy to say. but difficult to employ. There being no statutory definition thereof, more particularly in the IPC, CRPC, Indian Evidence Act, Lord Williams in Robert Stewart, Watch Coupe versus Emperor 1934-61 ILR. Observe, the expression honorably acquitted is one which is.
It's not that in any statute.
Yes.
Word honorable acquittal is an invention in the service
Yes,
jurisprudence.
service jurisprudence. It is not in the statute. Unknown to the Court of Justice. Apparently, it is a form of order used in court martial and other extrajudicial tribunals. The Apex Court in Commissioner of Police, New Delhi versus Meher Singh, 2017, 7 SEC, page 68, at para 25 explained the same. The expression honorable acquittal, acquitted of blame, and fully exonerated are unknown to the criminal jurisprudence.
Yes.
Or the penal code. They are coined by the judicial pronouncements, as
Correct.
your Lordship pointed. It is difficult.
It's my judgment only. You are reading now.
I'm grateful to your question.
Affirmed by the Supreme Court.
Yes. It is difficult to define what is meant by the expression honorably acquitted. When the accused is acquitted after full consideration of the prosecution case and prosecution miserably fails to prove the charges leveled against the accused, it can possibly be said that the accused was honorably acquitted. The idea of honorable acquittal is not easy to define, although it can be illustrated. If an accused is discharged at pre-trial stage or the criminal proceeding launched against him is quashed, there is no difficulty in treating the same as the case of honorable acquittal for the limited purpose of disciplinary inquiry. We are mindful that the question of acquittal comes post-trial. The case of honorable acquittal may be arisen when, after trial, the criminal court orders acquittal with any of the nearly the following illustrating. The accused is falsely prosecuted to seek vengeance for some ulterior motive.
Whether that sentence appears in your Jharkhand court judgment? It is not.
I will read thereafter. I will read that finding portion of the Jharkhand High Court judgment.
Okay.
So that it may be crystal clear to your Lordship.
Yes.
That there is absolutely no evidence to implicate the accused in the proceeding. It is very little evidence which is insufficient to connect the accused with the commission of crime. The prosecution has miserably failed to prove the charges against the accused. These points are there in the Honorable Jharkhand High Court judgment. The prosecution witnesses are unworthy of any credit. This is also point. Their version does not generate any confidence. We again say that above are only the illustrative and non-exhaustive. We would also add a caveat that in considering as to whether the case of delinquent is of honorable acquittal, the entire judgment in criminal case should be perused. It is also desirable to secure a copy of the record of the proceeding for examination. Unless the said exercise poses practical difficulty, at least it should be open to the delinquent employee to produce such copies. As to the role of inquiry officer in the disciplinary proceeding,
No, that role of inquiry officer
role of inquiry officer
may not be necessary.
Yes, disciplinary proceeding.
May not be necessary. That's not your case.
That is not
Your case.
And now, my lord, I try to show your lordship that Honorable High Court judgment,
Yes.
the finding portion, how my lord, Honorable High Court has found that.
Where have you taken up the contention that the judgment of acquittal handed by the Jharkhand court
Yes, ma'am.
is an acquittal with honor?
Yes, my lord. This
In
part-
other words, honorable acquittal.
Yes,
Where is that ground you have taken?
Yes, my lord. This part I have taken in the recommendation given before the appellate authority, my lord.
Your appeal is waited, there is no limitation over here.
Appeal is, my lord, appeal before the board of directors, my lord.
Yes, whatever,
Yes.
because your proven delinquency is of the year 2014.
14, my lord. Appellate order has already, they have passed the order. They have upheld the order passed by the disciplinary court.
So,
Correct.
So before, when, in 2014 itself?
2014 itself.
So when did you approach the board of directors? In which year?
At least. Yes, yes.
You have to be little.
19-1,
No.
2015.
Your friends are agitated. They are waiting for their cases also.
19-5, 2015.
No,
No.
So 19/5/2015, you were acquitted in the year?
No, 2020.
Exactly. So 20. So how can you say in 2015 that you are honorably acquitted in 2000 would be or rather?
That's what we are asking now. We are formulating the question of law.
Yes, madam.
Where a delinquent employee, after a disciplinary inquiry, is found guilty and handed a punishment, whether that can be set aside on the ground that in a parallel criminal proceeding, years thereafter, acquittal has been granted.
That point I have not taken. That point I have not taken.
That question arises in your case because acquittal is subsequent to removal.
So if you don't,
You may not take it. We have to treat it because
I may be
the problem, Mr. Pandey, is that if you do not take that point, then you have no case.
But I have taken.
Because either you have to catch the bull by horn. You can't, fight Sai or whatever it's called.
that will not help you now.
That will not help you now. It is all over.
Only 3 points will arise in your case. Again, we are saying. One is whether the inquiry officer was rightly appointed or not.
Yes.
According to you, he was not. Number 2, non-examination of the bribe giver is fatal to the case of the management. Number 3, the Jharkhand court has acquitted you subsequently. Fourth one, the punishment is disproportionate to the gravity of the guilt. These are the 4 points.
These are the 4 points.
So you have argued.
Yes.
Let us see what other side will say.
Yes.
You have no other point. All through
Yes, Madam.
2 hours,
Two more
same point
Yes.
is said to us.
Since your lordship was not satisfied with that point, therefore I will.
No, we don't say satisfied. Let us see.
Yes.
If he improves your case,
Yes.
sometimes opponent will improve your
Yes.
case.
One more point, Bharat, if your lordship so permits me. One
Yes.
more point.
Yes.
One more point for a recent judgment passed by the Honorable Supreme Court. Recent judgment by, to be very specific, 2010, Volume 2, ACC, page 772.
2010 cannot be a recent judgment.
Yes.
It's a very old judgment.
This judgment, the Honorable Supreme Court has held that an inquiry officer should act fairly.
Correct.
Inquiry officer should not be adjudicated. It's a fact-finding court, constitutional authority. It should be fact-finding. Here it is a case, my lord, the inquiry officer, my lord, bent upon to hold him guilty, which is directly against the judgment passed by the state of UP versus Saroj Kumar Sinha case.
Why bent upon?
Bent upon because of the reason, my lord, he did not wait for that criminal case to culminate.
Where is the requirement of waiting for culmination? P. Rudrappa says, the officer need not wait for criminal proceedings. They will take some decades.
Then I will not.
By that, if that is the proposition.
Waiting this, it may be counterproductive.
Counterproductive it may
If you
be.
say that because the inquiring disciplinary authority did not wait, inquiring officer did not wait, then that would be direct allegation of bias.
And one judgment is also.
For what he will wait?
Yes.
Did you ask them for waiting?
You see, prolonged disciplinary proceeding is always a grievance for the employee. That it is hanging a Damocles sword. It is not being concluded.
No, that cannot be part of this.
Yes, then another judgment is there, Malad, wherein that the inquiry officer has not taken the relevant evidences or the taken irrelevant evidences, then which is also not tenable in the inquiry.
All right. Let us see what your friend will say.
My lord, your lordship.
Yes, brother.
With due tradition of this honorable court, my lord, the Union of India is the opposite party number 1, and I am representing the Union of
India.
number 1. And number 2, we are not permitted to appear on behalf of the chairman of managing director, general manager, and chairman from.
But they are served now.
My lord,
They are served.
Who was appearing in the writ petition for them?
then in writ petition, my lord, learned senior counsel Shatidhar Das is appearing for.
In this particular writ petition, which was disposed of by the judgment, who are the Pati, I think. I don't know what you are responding.
Yes, I am responding. Just my lord, your lordship.
Who are the counsel appearing in that writ petition, sir? That is the question that is being asked.
Shatidhar Das and his associates. Whole India.
All right. So you don't want to say anything?
So, my lord, apart from that, since we are the assisting of this honorable court's officer.
Yes, assist.
So I only draw the kind attention of this honorable court, my lord. Your lordship, the present writ appeal, the government in this writ application, the writ appeal, in first title, my lord, they have stated that, I want to know, in that an appeal challenging the judgment dated 31/7/2024 passed by the Honorable Single Judge High Court Orissa in WPC number 18538 in 2021. And thereafter, my lord, in the in the first title also, the matter out of this writ appeal arises was before this honorable court in WPC number 18538 of 2021 disposed of on 31/7/2004. So here, my lord,
2004.
2024.
24.
My lord, here there are it may be a common order in both the cases, but both the two cases are in different.
Therefore, two appeals are to have been filed.
Two appeals, sir.
Go to next point.
Next point. In the first case, my lord, in first, that is according to him, WPC number 17035 2016, they have challenged the removal order which has been confirmed by the appeal. And another is that, my lord, in 18538 of 2021, they have challenging after acquittal. They have represented before the authority.
Saying that I have been acquitted there, therefore take me back to the duty.
Yes, that has been, that representation has been dismissed, and being aggrieved that they have been challenging this. Now
but both the petitions were treated by the same judge.
Same judge.
Same order.
Same order.
But that order is not challenged, is your version.
Yes, my lord. Otherwise, because if the writ appeal is filed against only the
one order,
last writ petition, that means they are not challenging
the other
order of the inquiry officer, the competent authority who has been dismissed or revoked from the case, ma'am. So this is the.
In other words, the writ petition that was founded on the order of Jharkhand court, that writ petition has attained finality, order in that writ petition, because that is not made a part of writ appeal at all. Another writ appeal should have been filed on that.
Mine.
How prayer, what is the prayer in the writ appeal? Just see. In prayer.
You will not see.
Go to prayer.
Under the prayer is that it is therefore prayed that this one could may graciously be pleased to admit the writ appeal, to set aside the judgment
only in 18538 of 2021.
No, in second they have stated that.
Huh?
In prayer number 2, to set aside the judgment dated 31/7/2021, passed in WPC number 18538 of 2021 by the Honorable Single Judge. Next 3, to pass and set aside the order of the removal from service.
Order in WP 18538 of 2021. This WP is?
Other one is 16. First one is 16.
Yes, 16.
No, 18538 of 2021 is what?
So that refusal to re-engage, obviously, is
After acquittal, post-acquittal stage.
But removal order, you have not you have sought for setting aside removal order.
No, yes.
Appellate authorities order.
Yes.
But on that you have filed a writ petition.
Writ petition number 2016.
But
so
why you are not challenged?
in your prayer, he is pointing out, you also assist us. At least you can tell that much also, that I have in so and so paragraph I have prayed for that. Or
no, you are
apart from, you have to challenge that on merits also, because the pleadings have to be there.
Yes.
But no, he had not challenged only. That order of the learned single judge, unless you put it in challenge, that remains intact. Take out 1992 Supreme Court. Take out this judgment. 1992 Supreme Court, page 111. But unless the order is challenged, it may be a bad order or it may be without jurisdiction. That order will remain. They refer to wait and force it.
Wait and force.
111. Take out that judgment. Yeah. Just read paragraph 5-6 of that judgment. You don't have that one in online facility?
Yes, sir.
Read paragraph 5-6-7. It runs, the paragraph runs like this: apropos to this principle. Anybody, you can read it. You only can read it.
Apropos to this principle, Professor Wade states the principle must be equally true even where the brand
of invalidity
is plainly visible
on the forehead.
For there also, the order can effectively be restated in law only by obtaining the decision of the court.
Correct.
Professor Wade sums up these principles. Should I continue?
Just say.
The truth of the matter is that the court will invalidate an order only if the right remedy is sought by the right person in the right proceedings and circumstances. The order may be hypothetically a nullity, but the court may refuse to quash it
because of standing.
The plaintiff's lack of standing.
Correct. This is the law. Unless you challenge, that order remains intact. That just refers to Radcliffe's judgment. In that paragraph, paragraph 5, Radcliffe, just see that judgment. Above, apropos.
You can search for Radcliffe.
That's what Justice Lord
Smith versus East Rural District Council, 1956, 736, Lord Radcliffe.
That is the English judgment. We followed that. Therefore, you are not challenged the order of the learned single judge in never writ petition, which negatived your challenge to the removal order and the appellate order. That is not put in challenge before us. Your only grievance is, I have been honorably acquitted, even that rightly not stated. Anyway, I have been honorably acquitted by Jharkhand court in criminal case. Therefore, take me back to the job. That's your case. But these will be the blocking factors. Anyway, assuming that even that is challenged here, that is one thing. The other on merits, what you want to say?
So, Pati, in the judgment, the single judge has upheld the disciplinary proceeding or has not gone into the disciplinary proceedings and is valid?
No, the Honorable Single Judge has upheld that there is no such irregularity, procedural irregularity.
No, I mean upheld
and then
valid
followed, so it should not be interpreted.
So both pending.
And apart from that, with regard to the mere acquittal, it should not be. That has been also taken by the Honorable Single Judge. Then your
yes, Mr. Pandey, you wanted to say something.
Yes, I wanted to say, my lord, the Honorable Single Judge judgment, my lord. Honorable Single Judge heard in holding, my lord, only holding that as if that I have challenged the writ application of 2021. The Honorable Single Judge has given stress upon several quoted. Honorable Single Judge has quoted, please to quote several judgment also. Specifically on the point that I have granted not honorable acquittal, so therefore my removal order is justified.
Yes.
But Honorable Single Judge, my lord, misconstrued in holding that the first writ application was, in first writ application I have challenged the entire disciplinary proceeding on the 4 grounds, just your lordship pointed out.
Okay.
I'm grateful to your lordship for 4 points, important points.
Yes.
And your lordship may be permitted to take your lordship to the relevant portion of the judgment passed by the Honorable Single Judge.
No, we'll assume.
Yes, paragraph 25. Paragraph 25, how it says, runs like this. It is pertinent to consider the principle of substantial compliance, which indicates that minor procedural deviation do not necessarily invalidate the proceeding. Here it is a case that is not a minor deviation.
No, Mr. Pati has already said that. Mr. Pati says that his contention is that the Honorable Single Judge has approved the disciplinary proceeding and the conducting of the disciplinary proceeding both procedurally and otherwise.
So therefore, my lord,
so now you have not challenged that aspect.
That has attained finality.
Because it is 2016, this petition. The prayer was different. That is much prior to your acquittal and other things.
Subsequently.
Or your challenge to the disciplinary proceeding in the writ petition was based on the acquittal.
But I have challenged the repression based on the acquittal in 2021 writ.
Original. Whether, I mean, you got acquitted by the High Court, by the Honorable High Court in
2020.
So in 2016 it could not stop us.
Yes, sir. 2020 and 2021 I have filed a writ application before this Honorable High Court of Orissa. And my lord, honorable single judge has taken the point.
16 was pending. 16 was kept pending.
Yes, my lord, kept pending both the matter.
Both they were together taken up.
16,
But
yes,
that order
yes,
he has
yes.
not challenged.
16 was kept pending.
But in
and
another way, when they you should have banked upon Paul Adhani. The problem is the criminal lawyers will not be knowing the service law. Service lawyers will not be knowing the criminal law. They think that they are all poles apart.
my lord, my lord.
Law is one system it is.
Yes. my lord.
All law should be known. Only then matters can be argued that
My
way.
lord. So therefore, my lord, honorable single judge has held that minor procedural deviation do not necessarily invalidate the proceeding. Here it is no case the minor.
According to you, it is not a minor deviation,
Yes,
it's a major deviation.
Major. Because complainant are not examined, material witnesses have not been examined.
No, he's on other things.
Yes.
Anyway.
And para 28, my lord, honorable single judge has held, after taking consideration of the order passed by the disciplinary authority and the appellate authority body, it is clear from the records that the departmental inquiry has been conducted properly. And their rule says so, my lord. Just I have pointed out 29.2 CDA rule says so.
Kindly do not repeat. We have heard you.
So therefore,
You have argued very well. We appreciate you.
my lord, done.
Yeah, that's a great thing. We appreciate you. On merits, you don't want to say anything. You are a party, and it is a public sector undertaking of your government.
Therefore, I seek the Honorable Court's permission because since I am appearing for opposite party number 1,
Yes.
so I am
He is
being
your
the assistant
respondent.
I am assisting this. Therefore, I am arguing my lord. Otherwise, the notice has already given. Because this Honorable Court has
Don't worry, they are not.
1/5/2025 notice the other party.
They are under the impression that we are all children of the government, therefore government will look after. They are under that impression. That is the reason Union of India is made first respondent.
Right.
Unless you argue, otherwise you have to write that there is no assistance from the government advocate, central government lawyer.
Even in the para 30 of the judgment, the Honorable Court is also held that, Honorable Single Judge has held that, in the category of judgment, it has been reiterated by the Supreme Court that mere acquittal does not automatically entitle an employee to reinstatement in service. The acquittal or discharge of an individual cannot by itself be construed as evidence that the individual was falsely implicated. Furthermore, it is essential to consider the nature of the charges and the circumstances surrounding the acquittal. Thus, a delinquent employee can be reinstated in service only when his acquittal is an honorable acquittal. That is also held, and subsequently he has discussed the judgment. So in 2-4,
Judgment after we come back, we will give dictation. On that, there is no decision. But I also, both my friend and my brother and myself thought over it. There is no law on the point. First time we are laying down that one. So that will not help you. Assuming that it's an honorable acquittal.
Yes.
An honorable acquittal that follows the dismissal order will result into wiping out the guilt. Law is not developed. We will develop it now. No standard books like Rama Jaisan services under the state, Kulashrestha, writ remedies in service law, and Samaraditya Pal.
Yes.
They have not discussed these aspects of these finer aspects. Therefore, we said, in fact, Paul Anthony, which brother mentioned, that benefit you should have taken. You should have said, stay the disciplinary proceeding till your inquiry for the criminal trial is over. That you have not done. You means your client should have done that. That there. You can't improve the case here. We understand your limitation. Therefore, kindly give us, permit us to dictate the judgment. We'll note all your point. We'll give dictation in your right, in your presence now.
Yes.
All right. Be seated. All right. Any other point you want to touch? Nothing. All right.
Really that is.
Excellent. Kindly be seated. Yes. You have to provide me the dates when we dictate, huh?
Yes.
Dates,
Yes.
number, that one.
One.
Okay. An employee removed by way of punishment handed in a full-fledged disciplinary inquiry is invoking the appellate jurisdiction of this court for laying a challenge to the to a learned single judge's order dated 31/7/2024, rendered in WPC number 17035 of 2016, connected with 18538 of 2021, whereby his essential challenge to the penalty order has been negatived. First, learned counsel appearing for the appellant employee urged the following grounds for the invalidation of impugned order. Colon. A. The entire disciplinary proceedings are vitiated in as much as under the extant conduct rules, it was not open to the management to appoint an ex-employee of the organization as the inquiry officer. And therefore, everything would fall down on the principle of ex nihilo nihil fit. Number 2. The complainant, who allegedly had tendered the bribe amount, ought to have been examined as one of the witnesses by the management, and that non-examination vitiates the inquiry proceedings, which aspect is lost sight of by the disciplinary authority, later by the appellate authority, and lastly by the learned single judge. 3. BC. The subject disciplinary proceedings were held not with the fairness standards obtaining in the realm of service law, inasmuch as some important witnesses were not examined by the management, nor there is any explanation for not examining them. Next. In criminal proceedings, although the trial ended in the conviction of the petitioner, of the employee, with a sentence of simple imprisonment for 3 years, come to 2 years. You said 3 years. Yes, come 2 years. 2 years. Coupled with rupees 50,000 fine, yes, comma, the same came to be set at naught by the Jharkhand High Court in a subject criminal appeal, and that it is an order of honorable acquittal which would inure to the benefit of delinquent employee, and this aspect of the matter has not been duly considered either by the management. When a representation was made subsequently for recalling the order of removal and a consequent order for reinstatement. Lastly, the punishment is disproportionate to the gravity of charges, even if the finding of guilt is upheld, and therefore the impugned order of termination is vitiated as being contrary to doctrine of proportionality obtaining in service jurisprudence. First off, in support of these contentions, learned counsel banked upon certain rulings of the apex code, which we shall advert in due course. Next point. There are 2 is over. There are 3 now. After the service of notice, the first respondent Union of India has entered appearance through its standing counsel, senior panel counsel, Shri so and so. Although the employer organization has chosen to remain unrepresented.
So that notice has not been issued to them.
They have not filed requisites.
Okay. First of all, however, no notice was issued to the employer.
Issued, but they have not filed a postal.
However, although notice was issued to the respondent employer organizations.
So, Bhakti, you are there for 1 and 2, na?
Only one.
You are always recorded as 1 and 2 because kindly look at the cost statement.
Yes, my lord, 1 and 2
No, can I look at
1 and 2.
No, not that way.
I have filed my appearance memo.
Only for-
1 and 2 my.
1 and 2.
1 and 2 correction.
Then
One India Bank.
Then you are there.
that Mr. Pandey was saying, that Chairman Board of Directors, OP2 is represented by you in the Learned Council.
It is separate panel council. You will have. Actually, inadvertently, ମୁଁ କଲାବେଳେ 1 and 2 office to instruction ଥିଲା.
No, he has not signed. That is, you have yourself by inadvertently mentioned.
Inadvertently mentioned to one. For office.
However, that would not make much difference for the kind of the order that we are going to hand now. Learned senior panel counsel representing the first respondent union contends that there is absolutely no scope for indulgence of this court. Semicolon. He repels petitioner's contention, employee's contention, that the order of Jharkhand court in his criminal appeal was an order of honorable acquittal. Semicolon. Even otherwise, an acquittal arguably honorable if is rendered years after the removal of employee on the basis of a disciplinary inquiry, no right of reinstatement would accrue to such a delinquent employees. First, lastly, he submitted that petitioner, the employee, has preferred this writ appeal only against the order rendered in WP 17035/2016, wherein challenge was laid to the order of removal from service as affirmed in departmental appeal. And therefore, according to him, the order of the learned single judge made in companion WP number 18538 of 2021 has attained finality, there being no further challenge thereto. First, there are four foundational facts of the case. A delinquent employee gained entry into service as accounts officer with effect from 23/12/2006 in the 3, this is Roman 1. 3 is foundational facts. Roman 1. First of all, he earned a promotion as assistant manager into brackets finance subsequently. He was served with a charge memo on 26/3/2013 in relation to demand and acceptance of bribery in a sum of rupees 20,000 by a particular person. First off, this incident happened on 28/8/2012, and a trap was laid by the CBI in which the pink test adopted proved positive. Pink test proved phenolphthalein test proved positive. First up. Eventually, petitioner was subjected to criminal trial in RC number 19A, capital A, of 2012 at the hands of special CBI court at
Dhanbad. Additional special judge 11, come special judge.
Anyway, special court.
Yes, sir.
For the offences inter alia punishable under the provisions of Prevention of Corruption Act 1988. First of all, he was convicted by order dated 21/1/2019 and sentence and fine as mentioned above were levied. First of all. However, next paragraph. Employees criminal appeal number 138 of 2019 came to be allowed. A learned single judge of Jharkhand High Court wide order dated 29/9/2020 and he was acquitted. First off, on the basis of, first off, in the meanwhile, the disciplinary inquiry culminated into order of dismissal, removal simpliciter on 23/12/2014. Is it correct?
1912, but it was communicated 23/12.
19/12/2014.
Yes, 19/12/14.
That was preceded by show cause notice dated 26/3/2013. His reply dated 10/4/2013. And the inquiry report dated 14/8/2014.
11/9/2014.
11/9/2014.
Yes, 11/9.
11/9/2014, to which she had sent a representation dated 27/9/2014. First off, when your appeal came to be dismissed, departmental appeal?
Departmental appeal 5/9/2016.
The departmental appeal against the penalty order also came to be negative.
It is 38/2016.
14/8 is correct.
Yes.
Inquiry report is 14/8 is correct.
It was forwarded on 9/11.
Inquiry report make it 14/8.
And appellate order is 30th/8/2016.
Came to be negative by order dated 30 August 2016.
16.
First off, he filed WP, first WP now.
17035 of 2016.
It has got your report. WP 17035 of 2016. No interim order was granted.
No entry wasn't.
And admittedly, no interim order therein was accorded by the learned single judge of this court. Next paragraph. After the acquittal order of the Jharkhand High Court, the delinquent employee made a representation seeking reinstatement, alleging that the same has wiped out the guilt recorded in the disciplinary proceeding, first off, that representation came to be rejected on which date? Your representation came to be rejected on which date?
9/4/2021.
On 9/4/2021. First off, this resulted into his filing WP number 18538 of 2021. First off, it needs to be mentioned that both the writ petitions were treated together by the learned single judge, and a common order which is called in question before us has been rendered. First off. Next paragraph. Para 4, 5. Yes. Having heard the learned counsel for the parties and having perused the petition appeal papers, we decline indulgence in the matter for the following reasons. Number 1. It has long been settled in the realm of service jurisprudence that a disciplinary proceeding is different from a criminal proceeding even when same substratum is involved in both of them. First off, there may be cases that would fit into the parameters of Paul and Thani, wherein the criminal proceeding, disciplinary proceedings may be stayed till after the parallel criminal proceedings are concluded. First off. However, that is not the case here. The dismissal, the removal from service was effected wide order dated 23/12/2014, and appeal against that came to be negative on 2016, August 38, 2016, some date he said. Above we have written.
30th of August.
Whereas the Jharkhand court had acquitted the petition of the appellant only on 29/9/2020. Is it right?
Yes, sir.
2020. First of all. Had disciplinary proceedings been pending when the acquittal order was entered, arguably there was a scope for seeking dropping of the disciplinary proceedings on the alleged order of acquittal, should it prove to be honorable acquittal. First off, that is not the case here. No rule is brought to our notice, nor any ruling is cited before us to the effect that where the disciplinary proceedings are concluded and employee is punished, and long thereafter an the delinquent who was convicted by the trial court emerges victorious, unblemished at the hands of appellate court, and in that situation he should be reinstated in service. First off, had the appellant been dismissed from removed from service only on the ground of conviction by the criminal court, he could have applied for reinstatement on the ground that said conviction and sentence are set at naught in the appeal. First off, even that is not the case here. First off, therefore, the acquittal order which the petitioner has earned at the hands of Jharkhand court, High Court, even if it is arguably honorable acquittal, would not come to his rescue. First off, we agree with the submission of learned senior standing counsel appearing for the Union of India that the acquittal order does not answer an honorable acquittal in the light of Ramlal versus so and so and P.V. Rudrappa versus State of Karnataka, so and so, so and so. First up. Next point. The second contention of learned counsel for the petition appellant that the management ought to have examined the star witness, namely one who had offered the bribe, would not impress us in as much as there is no dispute as to the acceptance of the alleged bribe amount. In his reply dated in his reply to the show cause notice dated show cause notice dated 26/3/2013. Is it right?
Yes, sir.
In reply dated 10/4/2013.
Yes, ma'am.
Given to show cause notice dated 26/3/2013. That means he has specifically made the admission stating that the amount was accepted for some other purpose. First, what is significant to note is that once acceptance of the tender is made, is admitted, the question of examining the tenderer would pale into insignificance. First up, the rule that admitted facts need not be proved is as old as mountains. First, therefore, this contention does not merit our countenance. Next. The next contention of learned counsel appearing for the appellant that the entire disciplinary proceedings are vitiated, is vitiated in as much as there is no scope in the conduct rule, extend the conduct rules to appoint a retired employee of the organization
as the inquiry officer. First, on repeatedly being asked, learned counsel could not draw our attention to these pleadings or papers to demonstrate that such a contention was taken up at the earliest point of time, that is, when the first meeting of the disciplinary proceedings was constituted. First off, it is a settled principle of law that objection of the kind has to be taken up at the earliest point of time. First off, a person who voluntarily participates in the proceedings throughout cannot turn around and say the proceedings are better unless such a lacuna is demonstrated from the record. Therefore, we do not agree with this contention either. Added rule of the kind which specifies who can be appointed as the inquiry officer cannot be treated as a sacrosanct norm, violation of which would give a coherent cause of action in the absence of demonstrable prejudice. First of all, what we are interpreting is a service rule of a central government organization and not the statute of Westminster Abbey. First, next point. The next contention that there were other witnesses whose examination, if done by the management, would have inured to the benefit of delinquent employee is too far-fetched an argument. First off, relevant witnesses ordinarily have to be examined is a rule of disciplinary proceeding. Cannot be much disputed. First off, however, it is for the wisdom and discretion of the management as to who should be examined and who should not. First off, the rule cannot be treated as a thumb rule that can be invoked invariably in every case. First off, rulings to this effect galore in the court libraries, and therefore they are not mentioned here. Next point. The next point urged by the counsel for the petitioner is that the punishment awarded is highly disproportionate to the gravity of the guilt coming out from the disciplinary proceeding. First of all, this again is difficult to agree with. Appellant is not a Group C employee. He was in a higher position of assistant manager finance. First off. Therefore, obviously he was associated with financial affairs of the organization concerned, whatever be the extent.
First off, records reveal that he was also one of the members of the tender committee. Tender committee. First off. Committee, and in connection with the subject tender itself, the bribe amount was offered to the appellant. First off, he having admitted receipt of the amount, took up a plea that it was not in the nature of bribe, but for some other purpose. First off, what that purpose was remains enigmatically mysterious, despite turning the pages of paper book. Once admission is made, although it is not conclusive, it becomes sacrosanct unless a plausible explanation to take away its effect is offered. First off, it hardly needs to be stated that it is the appellant who accepted the money and who said that it was for some other purpose. And therefore, it was for him to offer the explanation consistent with section 106 or 107, 106 of Evidence Act 1872, although Act is stricto sensu not applicable to disciplinary proceedings. First off, therefore, this contention also falls to the ground. Next paragraph. A last feeble attempt was made by the learned counsel appearing for the appellant that before imposing the penalty, he ought to have been given an opportunity of hearing as provided in the conduct. First off, this we do not subscribe to in view of the amendment to Article 311 which dispenses with the second show cause notice, the requirement of issuing second show cause notice once guilt is proved. Guilt is proved. First, last line. The rulings, last paragraph. The rulings cited from the side of the appellant are the following. These rulings have been rendered in a different factual context, and therefore their ratio cannot be invoked in the case at hand, which is as clear as crystal. First, it hardly needs to be stated that more than a century ago, it was Lord Halsbury of House of Lords who said a decision is an authority for the proposition that it actually lays down in a given fact matrix, and not for that, that would follow logically from what has been so laid down. Quinn versus Latham, Quinn versus Leatham, 1901, House of Lords. Take down the page number, so and so. Okay, next paragraph. Lastly, one more thing needs to be adverted to us in the light of submission made by learned senior panel counsel representing the Union of India, colon. What was challenged by the petitioner in this, what is challenged by the appellant in this petition is only that part of the learned single judge's order that dismissed his WP number 18538 of 2021, correct? And that no challenge is laid nor any pleading is taken in respect of the order whereby the companion WP number 17035 of 2016 was also disposed of. First of all, the Apex Court has in AR 1992 111 paragraph 5 and 6 has held that an order, if not set at naught in a known procedure of law, would remain valid even if its invalidity appears on the forehead, on its forehead itself. First off, in the above circumstances, this appeal being devoid of merits is liable to be dismissed, and accordingly it is, costs having been made easy. Amen.
Yeah, it's good week. Interpol arises out of the challenging the order passed dated so and so, passed in WPC number 18538 of 2021, taken along with WPC number 17035 of 2016. Stop. The records of WPC number 17035 of 2016 were not placed today before the bench. The said records were called for from the registry and for reference.
Thank you. You argued brief.
Okay. Yes, you copy. That's the judgment which was I cited.
No, there is a Apex Court said
Yes.
in 2023.
Yes.
You cannot pass the judgments like that. You should make a note of that. Which judgment you want to bank on, which paragraph, how it supports you.
Yes.
Otherwise, you will go on citing 100 judgments.
No, I have
You have to go on reading only.
no. I have made a bunch of judgment. Just I've cited, but in the short notes of my compilation. So they are I'm submitting. I need 2 copies.
One thing I will do.
Your trump card is Ramla.
Ramla is
Your trump card.
trump card.
Trump has discussed Ramla dictate and summarized.
Yes, please.
One thing it cannot be disclosed manner.
We may be wrong.
No, my lord.
Remedialization.
We tried our level best, my lord.
That's one very good. You are very
I'm grateful.
such a big case. You are so well.
Is accepted.
Yes.
On the little rectifications we may do, linguistic rectifications, paraphrasing, etc. afterwards. Okay? But this is the order.
Yes.
Okay.
My next item is 24. I am making a submission with the permission of Lordship because one fixed matter is there. One thing is that item number 24, I have highly requested. I am handing over and let the notice be issued. That is only thing. And
And with due apology, I must say with all.
Why everybody is saying apology? We don't
I am
understand.
saying that. I am saying that because it is beyond my case. I was totally
looking up so apologetic. I was looking apologetic anyhow. So apologetic.
I have had the finest exposition of law, and we were totally blown out. It is
Mr. Sorangi, you have to file this receipt in the registry.
I have
No, here he is not the.
no. I am having this leak.
No, you are not following.
Lordship, I record my submission that requisite have been already filed today.
Kindly just allow me, because once that the waiver, the superintendent has made a note, he has to carry forward that note saying that it has been filed, and so.
Yes,
So you please file it in the registry. So
I will file in the registry. So next time,
so take the original. How you will file unless you get the original?
My lord, with Lordship's permission.
Kindly allow me to see the Lordship has directed me to dictate the order. So Ramakanta Sorangi for the appellant. The learned counsel for the appellant submits that. Sorry, I'm still at the earlier recapitulation.
I know it. The Lordship is very meticulous.
No, I'm not open. I'm having a hangover of that.
Requisite has been filed today.
Just a second. Just. The learned counsel for the appellant refers to the order dated 1st of May 2025, passed by the ordinate bench, directing issuance of notice and filing of requisites. You have filed requisites. No, please don't. I don't require this. You have filed requisites by speed post or registered post.
I filed it.
How can that display? You know what you have done. You have taken notice by speed post or registered post.
I have done it by speed post.
Unlikely. I have missed it.
Person may carry it.
Just a second. Not sure.
My clock has 5 minutes.
Passed by the minority coordinator bench directing the issuance of the notice and filing of the request.
Not loaded. Coordinate bench.
Directing the issuance of the notice and
Issuance of notice in the limitation matter and filing of requisites by registered / speed post with heading. Stop. They submitted that due to inadvertence, the postal requisites could not be filed in time. The said requisites have been filed today in the registry. It is further submitted the receipt of filing of requisites has been filed in the registry during course of the day. Registry shall do the needful for issuance of notice. Fixing returnable date as directed earlier. List after is, sir.
Yes.
Whichever date Mr. Sarangi wants.
Lordship, please.
So that date actually we are not having in calendar as it has been said by my lord.
Any day in July.
List after 3 weeks. After 3 weeks.
3 weeks, all right.
It's all right, but unless a date is fixed, it will not be listed.
Some date you give.
21st July.
Yes, ma'am.
21st July.
Diplomats.
Also, I don't know 11.
renewal of the NOC by the Nursing Council matter. Another last time answer that the revision that NOC.
Are you ready or not?
Yes, madam.
You are ready. Okay. Opposite side? Fresh matter. Yes. What is this?
Refer to any rule or provision where they have the entire so that's the petition doesn't disclose. Did you copy the 2 copies?
You want renewal of NOC?
Yes, for that inspection, I have declared fees. For the inspection of other colleges has been done. My college has not been done.
Under which act, which provision NOC is granted?
That I have supplied the guideline matter.
The guidelines are there?
Yes. No, granted.
By the comment.
You are the only advocate who has given 2 copies. Thank you for that. Yes. This
Notification is there, and the procedure for is NOC is enclosed to that notification matter, and that procedure under procedure Roman 9 matter.
Roman 9.
Yes. The Chair of Council or Chairman shall issue the NOC for the process to be concerned as to the seal of the occupant of the government.
So you have right to NOC.
Procedure is the following. 1/6 is inspection and compliance.
Well, inspection they have done now.
No,
They have not done. You seek the inspection also.
that is my grievance.
Where is your requisition that you have sought for saying that we have done everything, all infrastructure we have done, and now come and inspect our institution?
My lord, that I have annexed 2 is my is my lord regarding renew NOC inspection. Annexed 2 page 44.
That we are completely with you that you have paid the fees. The question is different.
My lord,
Question is that Roman 3 compliance. That where you applied and that shows that your application you have annexed to the rate petition.
this receipt is in
You have not returned a copy of the application.
that application is online application. Sir.
The Lord DG, on advance copy served. Who is there? 1 and 2?
2 and 3 my lord senior.
One, please, myself.
The Lord DG. Upon advance copy served appears and waves notice on behalf of OP number 1. Mr. Rajani Chandra Mahanti, Product Council. Navin Saab
No, it's one.
submits that he has instructions to appear on behalf of OP number 2 and 3. And 6 for copies of the writ petition. The Lord Council for the petitioner shall serve copy of the writ copies of the
Another copy.
writ petitions. No, they are 2 different
Yes, already 1 copy served.
Give one more copy.
Nurses and midwives is a different organization. Lord Council for the petitioner shall serve an extra copy on Mr. Mahanti appearing for the OP number 2 and 3. Yes, what is the instruction, Mr. Mahanti?
My lord, I thought 2 days before, my instruction is the application form is not there. He has only given this receipt. The receipt is payment is made on 25th February when the renewal application form date was over. So there is no document.
No, why you did not inform him all this in writing?
No, my lord, he had given it to me only on Saturday.
No, your client.
Yes, my lord.
Why he did not answer? He should have said, read Article 350 of the Constitution.
My lord, I will get a reply to all what I said. I will give it a
Prepare reply.
Suppose you take that stand in the reply that he never applied, but he has paid the fee and you have accepted, but you have not informed him to pay, give the application.
I will get all the information.
So can he now apply for again or with the same fee or what is your?
My lord, I will see because I have
You have to file objection.
Then get what are the documents he has filed and what is the condition of the case.
That's
So that I can fill the counter.
How much time?
2 weeks time.
The learned counsel appearing for the OP number 2 and 3 seeks 2 weeks time to obtain instruction to apply to the court. And this after 2 weeks.
Well, when admissions will take place?
That will be September.
September.
10th of July. The record so the record was filed. Yes. As one line, the notification dated so and so issued by the government in the Department of Health and Family Welfare, providing for the procedure and issuance of NOC by the authority is filed in the court by the learned counsel for the petitioner and taken on record. Scanned copy of the
Item 12.
My message also similar in nature. Here I have applied for fresh NOC, not renewal mine.
Fresh NOC.
Fresh NOC. And in my application, I had annexed 1 series, page 12, start from page 12. After receiving my application,
Same.
same order.
Same.
office has not given before.
Same order.
Same.
You serving copy of the instruction,
Yes, sir.
10th of July.
Yes. Copy, sir.
Yes.
14 and 2 p.m. 40. Why 2 p.m.? So there is a matter item 40 marked at 2 p.m.
It's 2 p.m. Perhaps we ordered that way.
With an order letter. Hearing of a edit of the
Very other bench.
By the other bench or this? By the other
By the coordinate bench.
Because of the assignment in the distance, the order was passed in the last appeal.
Yes, what do you say? You are ready?
This matter is taken.
No, what happened, my lord? Last time prayer was made by the state for adjournment and therefore I objected it. That is why my lord kept it. The matter is very urgent and it will at 2 p.m. Because of the delay in getting some employees not getting it so due in the salary even for years together now. And that is the reason for which specific order was passed that end of 2 p.m. However, because of the change of the assignment,
We will record that the appellant is taking time since there is a change of assignment.
last time.
Yes,
Last
yes.
occasion.
We understand, but he seems to be unprepared. So, then what do you think? Since it's the after notice hearing matter, so
What happened?
way you have to please
I
consider.
am not objecting anything on this. What happened? This case will not maintain. I am not going to maintainability first. Thereafter, related to merit. It's not a maintainable because the review application was rejected. In limine has been appealed.
Where is the urgency? 2018 matter it is. Within 1 week, nothing will happen. We'll grant him 1 week.
If I don't fix the date,
So that
very urgent date.
Item 4G.
call next week.
The employee actually has retired from service, not getting it like that.
Is the retired employee?
Employed eviction now also during the service, the order was passed by state tribunal. State tribunal abolished.
Abolished.
Then the matter was the review application was filed here in the High Court. In the state tribunal, was transferred to here. No challenge was to the tribunal's order. That review application was dismissed, which was filed after 2 years. The grossly bad of limitation. That is challenge. Therefore, this way, the entire period gone and he is not able to get even the judgment that passed based on the order of the Supreme Court by the state tribunal. This is the situation. In our date we fix.
We'll fix a date now.
So that
Fix some date. All this matter on so and so at the request of the deputy G. ASC. Come on. Finally, no time will be given again. Yes, which 10 July. 3rd July. 3rd July we have about 6 matters. We should remember which all matters are posted on a particular date. Otherwise, all they will be bunched, na? So give some other date. 7th July. 7th July, all right. The court officer should remember how many cases are posted on which date.
Otherwise, impossible.
Otherwise, it becomes business becomes difficult.
Today's recording was there.
Let it be on in the list. You can seek passover. You keep your
No, I
colleague.
to argue the case.
No, we will be ready to hear your argument.
Yes.
Even it may be before 2 hours. Yeah.
I don't know.
It's relating to block grant employee seeking pension under the old rules. The Lordship keeping the matter on along with the WA number 197 Miller.
Connected matters.
Yes.
Sorry, call this matter
Yeah, Lordship.
along with.
Yesterday.
That's what. They are posted on 12/7.
The Lordship issued notice. Matter. This matter. The similar matter.
Similar. They are posted on 12/7.
7/7.
7/7.
Who is
Okay.
So here the notices.
Not dated date or issue.
2 weeks after.
Issue.
2 weeks after.
Huh?
2 weeks after.
Issue emergent notice, returnable in 2 weeks. Other things you have to pay. The compliance, that's for some permits is there.
They can
Same order.
Same order.
Print same order. Yes. Yes.
26 I would for next week. Next year.
2 weeks. 2 weeks on request of learned ASC, AGA. Yes.
Item 27.
The matrimonial this is preferred by the state Miller.
This is for admission hearing. Leave has not been granted.
Leave has not been granted. Only delay has been condoned. I am not the respondent.
So evidence on record filed or it has to be called for.
I think
Not filed, it is to be
the certificate document. The evidence is
Entire.
I also request for the
application.
You can argue thereafter.
The lordship is going to be possible. Grant leave and the case will be admitted below. Then the question of the apprehension of arrest will come.
Correct.
On surrender, he may be allowed to go and tell on section 390.
Now, once we want to know, at least I am not good in criminal law. Just I want to know, once appeal leave is granted, as a corollary of that, appeal has to be admitted. Correct? Or after grant of leave, one has to argue for admission. What is the legal position? Leave to appeal is one thing. Admission is another, is my impression.
It will again come for admission. Leave you get it, and
Then it becomes appeal perhaps. Once leave is like SLP,
Government appeal.
it becomes appeal. So leave to appeal is a must, precondition for appealing. Then it comes for admission. This is the procedure in at least in the court from where I hail. Okay. So we will grant leave and then we will post it for admission. What is the legal position in this state?
Yes, that is the
Same.
lordship.
Is it true? Same. Leave as sought for filing the appeal is accorded after looking into the papers. First of all, post for admission. Next.
I am not filed. Government has filed.
Government, we have filed counter.
You are in appeal now. You are in appeal.
And petition.
It's a lead petition.
I have to go through it. I have to defend the case. Yeah, account is only. Your lordship.
You have filed counter, but share a copy with them.
Yes.
Counter has to be shared with all the parties.
Yes, but they have entered later on.
Later entered. They are implemented.
Yes.
Subsequently.
But we'll search copy in course of this week, below. Let it come. Your lordship may call it tomorrow, next week.
No matter. After 2 weeks, so that I'll.
2 weeks. 2 weeks. 2 weeks. 2 weeks. Because this matter after 2 weeks. 2 weeks. Date you need date?
Yes, madam.
Yes. Some date. 9 July. Call on 9 July as requested. First of, in the meanwhile, the AGA shall serve a copy of the counter on the learned counsel appearing for
3 to 22. 3 to 22.
OP 3 to 22.
Paragraph 37.
37, my lord, I have some difficulty because I was appearing for the petitioners who are the respondent here in the
During your previous avatar.
Yes.
Okay. So we'll have this matter after 2 weeks.
After 2 weeks.
And you cannot appear.
No, somebody else will appear. My brother.
Call after 2 weeks. At the request of learned AGA, who seeks to retire from the case. And he assures that some other advocate would represent the appellant. Okay.
Paragraph 98.
My lord, this matter is akin to the series of cases with pending regarding that job contract and therefore work charge.
We call along with that
yes,
only.
Yes.
Call
7 July, you have lordship have fixed.
Call this matter along with writ appeal number.
Yes, writ appeal number, my lord. Item number 20 of today's list is the accurate.
17 and 20.
17 and 20.
17 and 20.
17 is the lead matter.
17 will be the lead case.
Yeah, 17.
17 and 20.
7 July.
17.
But we'll say call along with that because we don't know the date in that matter.
Yes, yes.
Yes. Yes.
Paragraph 49.
Then I will use the law. This matter of annual dismissed matter from 13/11/2022 pursuant to the Honorable State Record Ballot SLP and pursuant to the direction in the civil office that this matter has been extended to. But and I have glanced to flag B matter.
I was dismissed for default.
No, my lord.
No.
Remain filed before Honorable Apex Court and that is pending now.
That matter is pending. Against which order?
We're going to order part on 13/11/2023.
That matter is pending now. Any stay is not.
Remain pending, madam.
Huh?
So the state's appeal has been allowed.
Allowed.
So what do you mean by MA?
Mr. Bill, perhaps for the recall of the order had given the opportunity to the council for.
MA is a miscellaneous application.
Madam,
Appeal or application?
madam. It's pending now. It's pending the Apex Court, madam.
That is pending before the apex court now. Well, all right, we'll call this matter after 4 weeks.
Madam,
In the meanwhile, something has to happen there, na?
madam.
Call this matter. We are told that some related matter is pending before the apex court. And therefore, matter be adjourned by 4 weeks. First, call after 4 weeks. Okay.
Yes. Reminded. This is a reminded.
Paragraph 41.
Yes.
Item 41, my lord, I am for the petition. The application has been
Thirty-five.
It is 35.
35.
Yes, my letter has been raped by the opposite party, the accused. And he was.
For the informant.
I am for the accused. I am for
You are for the informant. Mr. Mitra is for the informant.
Yes. So far, PW1, PW2 and PW3 is concerned. PW1 was the victim.
State has not challenged.
State has not challenged. PW2, my lord, the informant. PW3, the father of the victim. Victim was identified, the accused. Victim was a mentally retarded person. And the prosecution has not examined the doctor who has conducted the medical examination of the victim. The doctor who has conducted the medical examination of the accused. The person, those who were, and he was
red-handed cut. The accused was red-handed fought by the PW2, and it is mandates under section 30 that the special public prosecutor is to conduct the case. And there is a series of charge-sheeted witnesses. The APP was not authorized to conduct the POCSO case. He has declined all the witnesses, 7 except only 3 to 4. The doctor is a material witness. 164 statement has been reduced in writing.
We will come after reading the papers.
Pardon. Your Lordship may call for the
one
LCR.
adjournment to us.
Your Lordship may call for the LCR because deposition is material. It can
They should prepare the paper book here.
To examine because you have appeal task.
Yes.
The parameters of appeal against acquittal.
Yes,
please
Your Lordship,
examine and
correct.
Come back.
Here the question is that the accused who has been identified, the learned trial court has said that a mentally retarded person who can pardon.
Mr. Mishra, the victim identifying the accused cannot be the last. It can be the first led in the court.
First led.
The last. So you have to have some other material.
PW2,
Just examine
PW2 only. And the medical exams.
You have to yourself examine what best material you have against the accused.
Yes.
That you have to bring to our notice, and we are calling.
Your Lordship may call for the LCR. It is better because in the LCR it is in details.
Call for LCR. Post after 3 weeks.
So to Mishra for the petition. You have filed caveat or how you got?
Notice was issued.
The notice issue.
Yes, notice has been issued. My friend has already.
Actually, this is the leave to petition. Yes, fine. In the amendment, after amendment of the 372 CRPC, it is not necessary for file
Leave it all.
Leave to. So
But
it is,
whether that amendment-
it is CRLA.
No, amendment, you can file appeal itself
Yes, ma'am. It is
under the new code,
But no, my lord.
earlier only.
419, section 419 of that BNSS. Subsection, my
No,
lord.
why BNSS? This is a prior
This is
to.
earlier.
That is earlier 378, my lord. Power is
372. 372 amendment, my lord. There is a right for the victim to file an appeal.
Appeal. But the appeal, right of appeal
Well,
arises when the original proceedings are filed.
Yes.
And it metamorphoses into full cause of action after final order is passed. This is what Supreme Court has said. Your right to file appeal arises when you file the suit itself. But right becomes cohate after you suffer an adverse decree. This is what 4-judge bench of the Supreme Court has said. Number one, right of appeal is a substantive right. Therefore, that right has to be decided as on the date the order is made. As on the date order was made.
So Garikapati Biraya.
That's what. Correct. Therefore, that now this new statute, is it with retrospective effect?
No.
Then then the leave has to be considered, etc. Just look into it and come back. We'll also look into. All right, call after 3 weeks. Heard. Let counsel say so and so, so and so, so and so.
The record is appearance.
Yeah, record.
Sir, T.K. Mishra for the petitioner. Mr. J.K. Khandayat for state. Mr. Mishra Tripathi. Mr. Tripathi submits that he has filed Wakilatnama pursuant to notice issued by this court. Call for LCR.
I have taken all endeavor. It has been served upon the accused person, my lord, within a week, my lord, on 15/3/2025.
It's heard already.
My lord.
But we made that order.
You file a petition.
It is not yet signed.
Has it been signed?
Signed. It is signed also.
No.
Huh? Not signed. Not yet signed.
Today's
I have
order.
also,
I have not signed.
You're not signed. Then all right. Then we will have this matter. Next week we'll not pass that order. Personal presence. But your police officer should be warned. When court directs service of notice through police, simply they should serve notice
exactly.
and come. If court tells them to jump from the first floor, they have to jump unless order is stayed.
My lord, may I say, it may be on BC.
No. Personal presence is always personal. What is that we see?
No,
We want to.
No, you are saying that it was your inadvertence that it has been served, but you could not provide that instruction to court.
They have not provided. That now I have received.
You have received that, they have served it.
Yes,
On 15th of March.
on 15th.
It is.
That is the signature of.
So
both of them.
that only call that matter some next week, week after next someday.
Yes.
Okay?
Item
That order need not be briefed.
Item 13 mil.
13.
Simple adjustment.
See that. Agenda by 2 weeks.
Deep blue.
All.
Do you apologize? Remaining matters will come next week.
Next week or week after next.
Nice.
Spread over. Okay?